Yes, ma'am. That was 16, no?
Yes, sir, 16. Submit. Change my words.
Just list it, what is convenient whenever is. Just whatever convenient.
Tax matter, serial number 1, Shri Akash Shetty. Serial number 1.
May it please, my lords, I appear for the respondents, my lords.
A refund of bank guarantee, my lords. To receive instructions, my lords.
My lords, I have the order, my lords. My colleague is carrying the order through which this interest has been allowed and credited to me, my lords. That was on 30th June 23, my lords. And I have the order which I can place before my lords.
Yes.
I've asked for the written insofar as the date on which the interest was granted and the time period to which the interest was being calculated, my lords.
My lords, it's in the order, my lords. Mentioned in the order.
You see this order. See this order.
Para 7, my lords, on the second last page. Has the period, my lords, if I may read, my lords, as para 7.
This is for which period? 19 to 22.
My lords, this is from 19 to 22, my lords, at 6% as per the directions.
That's the direction of the learned single judge.
Please, my lords.
If you see the direction of the learned single judge at page.
My lords, that your lordships will find at page 26, my lords. 26 at the top, in my considered opinion. Interest of justice would be met if the respondents are directed to pay interest in favor of the petitioner at the rate of 6% from 29th March 19.
And if you see paragraph 7,
it's the same period.
I just say 5th line, I opine that 6% annum, which is normal course, is the rate of interest payable for delayed sanction. Considering the same, the amount of interest on the amount this for the period this works out to this as against this computed by the claimant. Since the claimant has agreed for the rejection of this, which is excess claimed, I incline to sanction.
Correct.
Order 7873-057. So we'll do one thing. We'll just pass over. Just say that this is the order which has been given to you. What do you have to say? And this by this sanction has been done. Has the amount been received?
My lords, the amount has also been credited to our bank accounts, my lords.
Credited, my lords.
It is, my lords.
What? What do you want?
My lords, I'll seek for a password, my lords. I'll reset and
Okay.
Serial number 2, Tribunal Krishnan.
Here for the appellant, my lord.
Lords, I appear for the official liquidator, my lords, of the respondent entity, my lords.
Pardon?
I appear for the official liquidator of the respondent entity.
Yes. Are you ready?
I'm ready, but my lord, with new developments, I don't think my learned friend will be able to take up all the defenses which the company had taken up, because now it's official liquidator. Now the short point is whether the tribunal can remand a matter back to the adjudicating authority, because the Act only provides for setting aside or modification of the order. So, in fact, we had a discussion with my learned friend also in the morning. So, man, even the trial records may not be required. So, only at the point of law, my lord, a date can be fixed. We can go on. I think my friend also would agree to
What do you say on that?
My lords, I agree with the point on the official liquidator not being able to take certain contentions already raised in the objections. And there have been, of course, there have been subsequent events. In fact, the properties...
We have transferred some money to them also. We paid them some money also out of this.
My lords, the properties that are under attachment in the POA and the adjudicating order and the impugned order before this court have been subsequently confiscated under the Fugitive Economic Offenders Act.
Who has filed the objections? The liquidator has filed the objections?
No, my lords. This is the management, my lords.
Then do one thing. I think you put your stand also on record. In the sense, file your submissions, note of submissions.
Please.
I think let that come from the official liquidator who is representing the company. I think that would be better.
Yes.
Huh?
Please. And there are, as I said,
You also file Mr. Unnikrishnan.
Yes, my lord.
He will file it because the objections were filed by the erstwhile,
Yes,
the
sir.
company.
Yes, yes.
Please,
Better let the stand of the liquidator is also here.
please,
And
my
now,
lord.
my lord, this particular amount has also been confiscated to the central government under the Fugitive Act.
It has been done.
Yes, that has been done.
My lords,
Now
I
they are
have-
asking for some money to file litigation. Now, my lord, there are many litigations. Now the official liquidator has stepped into the shoes of the company. So they are now fighting cases, and we have also paid them some money to fight the cases.
Just
My
say
lords,
that it is,
So there's
In
no
as per-
adversarial litigation as such, except for the point of law, wherein the honorable tribunal, my lord, remands back the matter to the adjudicating authority, which in my opinion, my lord, is not right. That's only point which is involved. Let him have his say, my lord.
let's put it on.
My lords, of course, the point of contention also is whether the confiscation could have happened at all. Because there are certain properties which are in the control of the official liquidator as on date. Those properties have also been confiscated and have challenged it in a separate writ
A
petition.
separate writ petition is
single
pending
judge.
for that.
Oh.
That issue is pending
Ah,
separate.
Therefore, my lords, my request would be to defer a hearing in this matter until I'm able to get a decision in the challenge to the
See,
confiscation.
we say nothing on that. We will only say that you will file your note of submissions and defer the matter.
Please, my lords.
It is just say that it is directed that the counsel for the parties shall file their note of submissions. Within how much? 4 weeks. We'll say 4 weeks. Have it in January 2nd week.
My lords, if it could be in the last week of January, at least I'll get that time and opportunity to pursue the writ petition before the single
We will
judge.
see on that day. We will see on that day. We'll have it in 2nd week of January.
Please.
Okay.
Please.
8th of January, 8th of January, sir. Serial number 3.
You ready?
Short extension of time to file paperwork, my lord, today.
So like, we'll see no need for paper book. We will see it ourselves. Pass over. We'll pass over. We'll hear you.
I'll grant me 2 days time because Monday, Tuesday, last I kindly have.
I appear for the
I'll get
respondent.
ready, but I thought the paperwork has not been for this reason. I could not.
We'll give you time. Just go through it. We'll just call after the list is over. We'll call you. Okay, pass over.
Self a little time.
All right, we will also see. Let's see that. If you have any difficulty, we'll adjourn it. Not an issue.
Yes, ma'am.
Just look into it.
Yes.
Serial number 4. Sri Kiran. Serial number 4.
For the appellant, ma'am. Password.
Yes, ma'am. You were to file an affidavit. You didn't file.
Kindly
You
pass
filed the affidavit.
Password, Abhisan.
Very well. Pass over.
Serial number 5.
Ma'am, you have to serve respondent number 1.
You know, we have.
You have served the council, ma'am.
Huh.
The
We-
council is also not present. Better now you serve the party.
Yeah, we had taken steps, my lord. It looks like it's returned.
But report says
yes.
not served, and he is the contesting party.
Yes, no, my lord, we'll take steps again. We'll take
That
steps.
fresh notice. be
Meanwhile,
issued.
you know, one more thing, my lord. I mean, as per the cause list, we had like now that a conditional.
I
stay
know,
was
I
there.
know, insufficient funds.
Yes, my lord, I mean, my apology, my lord. And
Very surprising. It's actually surprising.
surprising. My lord, I request for my lord,
Yes.
my lord, 1 week's time, my lord. And we will now, I mean,
The-
advise client to, my lord, give demand draft instead of check, my lord.
No, why not check also? NHAI. Fine, whatever you want to, just say this, I mean, just show the app with this thing. Order sheet. Let fresh notice be issued for service on the respondent.
Number 1, yes. my lord.
Number 1. The report of the registry suggests the check submitted by the appellant, deposited by the appellant, has been received back. Has been received back with the observation funds insufficient. The learner counsel for the appellant states that the amount as directed in terms of order dated
My lord, 5th August 2024.
in terms of order dated 5th August 2024
24.
shall be deposited by way of a Demand draft. Demand draft. Within 2 weeks from today, noting the said submission, comma, time is granted to deposit the. Just one, does it say check the last order? Hmm?
You know, there was no, I mean. check
Full stop.
also deposit.
Further action on such deposit, further action shall be taken in terms of the order dated 5/8/2022.
Interim order may be extended till.
Full stop. The interim order has passed on 5/8/2000.
24.
Shall continue till the next date of hearing. Yes.
Obliged.
21st January. Serial number 6.
I appeal for appellant in this case. my lords. Speaks for 2 weeks' time. Our senior is hospitalized since 3 days, my lords.
Just say objections you have to clear, na? At request of counsel for the appellant, re-notify.
17th January.
My lord, interim orders may be extended.
What is the interim order, ma'am?
My lord, stay of the trial court, my lord, for eviction.
But why are you seeking adjournment?
My lord, senior is hospitalized in Manipal Hospital, my lord, with cardiac complaints.
Pardon?
Senior is hospitalized in Manipal Hospital, my lord, with cardiac complaints.
Just say that adjournment is sought by the counsel on behalf of the counsel for the appellant. That arguing counsel is unwell. Adjourn to interim order, if any, to continue.
Grateful.
Serial number 7. Gopal Swami.
Appear for the appellant, my lord. My lord, in this case, I produced the petitioner.
Petitioner respondent.
Petitioner. For the appellant, my lord, I have produced the
Just
family tree issued by the government of Karnataka.
Papers of the petition.
yes.
Please, my lord, I filed a memo producing the copy of the order issued by the government of Karnataka of the family tree regarding the appellants, my lord. In that case, it is very clearly mentioned, my lord. Srimati Vijay Lakshmi, who is one of the appellant, he died, my lord, she was unmarried. And the other legal heirs are legal heirs. Other persons, appellants are the legal heirs.
Copy is not so long.
Yes, this is an LR application.
I have not served with a copy minutes.
You have not, they have not.
Not served with a copy.
Just give him a copy of the
Please,
appeal.
my lord, I will serve a
Have
copy.
the copy of the appeal.
No minutes.
Let a copy of the appeal be given to the counsel for the respondent NHAI. Full stop. The counsel for the appellant shall also file the English translation of the Kannada documents before the next date of hearing.
Please.
21st January. Serial number 8.
But the petitioner, my lord, is a landlord. Respondent bank was a tenant. But it had not vacated the premises. I filed a suit not for eviction. Suit was decreed. Lord, fixing not about 100 rupees per square feet for a certain period, then 150. But the bank came in an appeal. In the appeal, not both the parties had filed not the memo of calculations. But even according to the calculation filed with the bank, the amount not payable is about 57 lakhs.
Unfortunately, not in the order, not there is a typographical error.
Which order?
Order of this normal court, not which is not sought for. How? But what happened was not the calculation filed by both the parties. In fact, my calculation was 54 lakhs. His calculation was 57 lakhs.
No, but tell us one thing.
Please.
What follows if the correction is made?
But then nothing remains. Bro.
Nothing remains. Is he ready to pay?
But that is his own calculation. Not matters disposed of.
Oh, disposed of.
Matters disposed of, not granting him the bank time to vacate.
That's before the court below, no?
No, it's already disposed of. Not.
Oh, here also.
But the suit not filed by the landlord not was decreed.
So this is only on an application.
It is on application. I've also filed a review because the court felt not I have to file a review because what has happened is not in the operative portion of the order, not the court has said inclusive of GST. Not GST not should be added to the rent. Not it cannot be not said inclusive of GST. Because their calculations also not is to that effect. Not kindly permit me to take notes to the order. But that will make it very clear because the body of the order says something else, the operative portion says something else. But can I request not please turn to not page the review petition, if not, so kindly turn to. But page 23, not the order starts. Can I request the court to please turn to not page 25?
Page.
Not page 24, not please turn to. I'll just show notes the scope note of the appeal then. My lords have it not? But this commercial appeal is filed by the appellant challenging the judgment passed by the commercial court in so and so. The suit of the plaintiff came to be dismissed and tribunal has directed to vacate and deliver vacant note. This is again a typographical error of the suit shall be premises and defendant is directed and ordered to pay a sum of rupees 31,29,000 so and so to the plaintiff towards means profit at the rate of 6% interest and is also directed to pay future means profit at 150 rupees per square feet from so and so. During the hearing of the appeal, so and so learned counsel for the appellant submitted that the appellant is ready to vacate and hand over the premises. If some time is given to vacate, appellant's counsel submitted COVID-19, the bank is not able to mobilize their fund and deposits and the means profit ordered by the court at 150 is highly exorbitant and not tenable and the same may be reduced to rupees 65. On the other hand, she so and so counsel for the respondent submitted even for the vacant land. Now the rent is very high. Despite of the scheduled property situated aside of the suit property. Therefore, 150 rupees is quite reasonable. Both sides are directed to file memo of calculation. But then para 4, accordingly, the learned counsel of the appellant, no, that is the bank, has filed a memo of calculation dated so and so. And has also filed a memo of calculation chart at rupees 100 per square feet with GST at 18%, which reads it under. But the bank calculation is set out, but I will not trouble reading entire thing. Please turn to page 27. The penultimate note, second and third note chart. Differential rent to be paid from 1/7/2019 to 39/2022 with 18% GST. According to the bank itself, not it's 57 lakhs. On the right hand side, notes get it 57 lakh 58,990. But that is rent plus GST. But then the next calculation that they set out was difference of rent payable and paid without GST is 48 lakhs. But then not para 5 is my calculation. Respondent has filed a memo of calculation on so and so, which shows the total rent receivable is 54 lakh 1,000 so and so till September 22. The memo of calculation filed by respondent is just here under. But then please turn to para 6. On verifying the memo of calculation, it is found that there is slight difference between them. We have perused the documents filed by the petitioner and respondent along with the memo of calculation, amended lease agreement dated so and so and lease deed dated so and so. It is evident that the rate of rent is very high in respect of similar situated premises in the said area. Consider submission by the learned counsel, opinion for the appellant and respondent and their contentions and the memo of calculation. We deem it appropriate and it ends of justice to direct the appellant to pay future means profit at rupees 100 per square feet from 1/9/2019 till September 2022. We also direct the appellant to pay future means profit at 150 per square feet from 1/12/2022 to till possession of the social property is handed over to the respondent. But then para 8, time is granted on the basis of undertaking of the bank. Now, my lords, please permit me to take notes to the operative portion of the order, which starts at page 31. But the first portion, my lords, may skip it. Page 32, my lords, please turn to clause B. The appellant bar defendant shall pay rupees 31,29,068. But this is the amount that was mentioned, my lord, in the trial court decree to the respondent plaintiff towards arrears of means profit from so and so till so and so at rupees 100, including GST, with interest at 6% per annum. Then, my lord, clause C. Appellant is ready to pay future means profit at 150 per month, including GST, from so and so till the date of handing over possession. But basically, my lord, it was a typographical error, my lord, in the order. Because, my lord,
What is typographical?
Lord, the amount that is mentioned,
As
not amount ought to have been mentioned not as per the bank itself as 57,58,990. But
what
amount
has
that is
been men- What has
mentioned,
been mentioned?
31,29,000.
Okay, and including GST, you have an issue.
Yes, Lord, including GST, because not as per their own calculation, inclusive GST, Lord, is what is mentioned as 57 lakhs. Not that first portion is all right. The second one, Lord, at the rate of 150
No, if
plus
this-
GST is what
according
should
to
be.
you, if this figure of 31,29 is corrected as 57,
Yes, Lord.
the including GST would be right.
Yes, Lord, it would be right. But the second portion, not clause C, not it is 150 rupees is what the court has ordered in the body of the order. Not it should be 150 plus GST that he has to pay.
But once that is inclusive GST, why not the other figure?
But that is because the calculation was set out.
57 lakhs.
Yes, but that is not 100 plus GST. The calculation was such. But that note should get it.
100 plus GST?
Yes, Lord. Page 26 notes, please turn to Lord. Bottom of page 26. The bank is also calculated accordingly, Lord.
And GST at 18%.
Yes, Lord. Page 25, kindly turn Lord, bottom of page 25.
My lord, after submission of this calculation, my lord, that the bank has not deducted TDS. So that month-wise calculation was submitted before the honorable court on 21/6/2023, mentioning it is not 57 lakhs, minus TDS will come to 44 lakhs, 43 lakhs, 22,863. It was submitted before this honorable court.
When is
Not
that?
57 lakhs, because this memo, my lord, it was submitted before the court stating that TDS was not deducted. So monthly bank calculated each month from 19 to 22.
How much it is coming to?
43 lakhs, 22,000.
But not 31, no?
No,
Not 31.
not 31. But it comes to 43 lakhs.
Where is that memo?
Memo is, I'm having my memo.
Give it to him also.
Well, that also given my lord that time.
You
Because
have
it's
that?
submitted before the court, honorable court.
Lord, this is the memo.
The memo.
No, this is 21st June memo, what the learned friend is saying. But the appeal was disposed on 16 November 2022. My learned friend is showing a different memo.
No. He's saying 8/2/23.
Yes, not. The order was passed by this honorable court on 16th November 2022. What my
right.
learned friend is now saying is a different memo.
You're right, that's what he's saying. He's right. He said that when the memo was filed, 57 was reflected and that's how it was disposed of.
Very well.
But later recalculation made and the calculation coming to 43 lakhs. That's right?
Yes, my lord. That is, I submitted a memo also before the honorable court. And it
So
was
what he's saying is, if going by 100 rupees per square feet, which possibly, how much GST is separate?
Yes, GST has to be separate, not.
How much is
Your
GST?
lordship may guide.
18% GST, Lord.
My lord, this is,
Now tell us one thing.
yes, ma'am.
Have you calculated this new memo calculations on the basis of this judgment which was disposed of in 22?
Just my same. Correct, my lord. This matter, this was filed. before this
No,
only.
no. Have you calculated on the basis of 100 per square feet?
Yes, my lord.
Then excluding GST,
Excluding GST.
where do you get that?
No, my calculation, what monthly calculation is there, my lord. Your lordship kindly see that memo. Month.
But you say
Rent-
rent
rent
including GST.
Rent inclusive of GST. Paid, payable, TDS 10%, net payable.
That's right. But will it be including GST or excluding GST?
Including
Now-
GST comes so much, 43 lakhs.
No, but the order is your initial calculation
Yes, ma'am.
was initial calculation was 57 lakhs excluding GST.
Yes, madam.
No, no,
That's right.
including GST, 57 lakhs, he said. With GST. At
Very
page
good. 100 plus and GST at 18%, it is coming to
57 lakhs.
very good. 57 lakhs.
Now this collection, my learned friend, what he does, my lord, is he goes as per this order
Ah.
and includes the GST plot within this 100 rupees,
Sure.
which not is not permissible.
That's what.
Your lordship may kindly grant 1 day time, my lord. Tomorrow I'll file that detailed objection because now here my lord is changing the entire order. This is the review petition. Now this honorable division bench has confirmed the order passed by the learned single judge. Sorry, the trial court. Now this entire thing now includes now this order and all now what?
But
is
then
implemented, my
the
lord.
only mistake he is pointing out is it is not 31 lakhs.
If it is not 31 lakhs, it comes to 43 lakhs according to the bank.
Now, but we want to know,
Yes, my lord.
once that order has come when 31 lakhs was reflected,
Yes, my lord.
did you make recalculation making 31 lakhs plus GST
Yes, my lord.
to mean 43 lakhs?
Yes, my lord. Here, my lord, that.
See, it's simple. Just listen to us. The base price, you will keep it as 100 per square feet. Then calculate saying including GST. Okay, effectively, whatever calculation you will make, you will subtract 18% as GST. Okay, as GST, reflect both the figures. What is 100 per square feet plus GST, how much amount? And minus GST, how much amount? That's how you have to
Yes,
do it.
that
is all, my lord.
That I'll file.
In fact, Lord, the matter was not heard on merits. On the basis of this memo of calculation, Lord, they said, I need some time. And that is their own calculation, Lord. Now my learned friend cannot go contrary to his own calculation, Lord. The bank said it is 57 lakhs, Lord. I said it is 54 lakhs. My calculations said it is 54 lakhs. Their calculation 57 lakhs. I'm not, GST is always not added to the rent. It cannot be deducted, Lord, from the rent payable. And that is how they have been paying rent all throughout. Earlier, Lord, it's a rate of 43 rupees per square feet was a rent. But before, Lord, termination of the lease. Plus GST is to be added.
But here.
That is how, Lord, they have calculated. Lord, page 26 is their
Do one thing,
calculation.
you file your fresh calculation.
Yes, my lord.
Give the breakup. 100 square feet must be the 100 rupees per square feet is the base price.
Yes.
You will, what is the area into 100 and how much component of it by going by this order is inclusive of GST. Then you will separate minus 18% GST, how much it comes to give the figures.
Yes, ma'am. Then another
Very
one
well.
more is regarding.
I will also make a calculation, Lord, so that.
But you will make a calculation based on this. Let's be very clear.
Very well, Lord. Lords are saying, Lord, 100 rupees per square feet plus GST.
See, what are the directions? Your case is 31 lakhs is not the right figure.
True, Lord.
If even going by 100 rupees per square feet,
True, Lord.
then you will work out, he will also work out. What is the price? What is the total calculation? We will see. Mind it that whatever his figure is arrived at is inclusive of GST.
Very well, Lord. I understood.
Proportionately, if it is inclusive of GST, proportionately the square feet amount will reduce because
Yes,
the GST is included.
But there, Lord, that is the difficulty, Lord. The order says 100 rupees per square feet they have to give me. That is a rent payable. Therefore, my Lord, it has to be plus GST.
We don't know. It says inclusive of GST. It doesn't say specifically. It's like 100 per square feet. They have fixed that base price, including GST.
But that is their calculations. That is why, my Lord, this court said you file at the rate of 100 rupees and 150 rupees from such
Then a
date.
counsel for the
One more component is there, my TDS, that has not been deducted.
TDS is a matter of law. TDS.
law that in any case follow. He will not object. to
Yes.
this.
Yes, that is all mine.
The learner counsel for the parties seeks time to file a fresh calculation on the basis of the judgment of this court dated
16th November 22.
16 November 2022. Within how much time?
Lots may same not at the rate of 100 because as per this judgment, Lord, again,
Right.
otherwise.
Then it is changing the.
At the rate of 100 and
At
150.
the rate of 100 rupees per square feet.
At the 100, but inclusive of GST. That is what my lord.
100 rupees per square feet, inclusive of GST.
Yes, fine.
Inclusive of GST.
Yes,
Including GST.
including GST.
But
With interest at 6% per annum.
Yes, my lord.
but inclusive,
From 1 to 2022.
Yes, my lord.
can I make one request, Lord?
And also, and also the mean profits at the rate of 150 per square feet per month, including GST from 1/12/2022 till the handing over of the
Yes.
vacant
Yes.
possession of the
Yes, my lord.
premises
Lords would
within
permit,
4 weeks.
Lords would permit me to also not show excluding GST so that, Lord, it is clear that, Lord, the calculation what they had made was not one place inclusive with the other place was excluding. So not permit me to not show both so that there is not more clarity in the matter.
As per the order only, that inclusive only will calculate.
You will show that.
I should, very
We will
well,
not put it on them.
Yes.
very well, Lords. For next week, not, can I request?
Although we have given 4 weeks, you just give it after 2-3 weeks.
Very well, great.
17-12. Serial number 9. To Sandeep.
My lords, for the appellant, my lords, in this, we haven't received, my lords, we haven't received copy of the LRIA, my lords. Further, my lords, the arguing counsel's father has passed away. So there is some inconvenience.
Application.
Yeah, I'll give a copy of the application.
Let a copy of the IA 1 of 24 be given to the counsel for the appellant during the course of the day. The counsel for the appellant also seeks an adjournment on the ground that there is agreement in the family of the counsel for the appellant,
Please, my lords,
counsel for the
my lords,
adjourn to
interim order to continue, my lords.
interim order, if any, to continue.
Please, my lords.
My lord, I may seek for a date, my lord. The reason is.
We are giving you date. We are giving you date.
15th January.
Let me request next week, next month, not 15 February, February.
All right, let you have both
December,
doesn't permit.
December.
So, you see, we have any date in December?
Because the respondent have also lost her husband. Now they have no livelihood. They have deposited certain amounts before this honorable court.
11th
Immediately
December.
after coming, we have to speak with
Sir,
her.
11th December.
Much request.
Serial number 10. Vasudev Naidu, 10.
No time for the respondent. Yes, you are ready.
My lordships, there is a delay of 62 days, my lordships, filing the petition.
Filing appeal.
Beyond the stipulated time, my lord. It cannot be permissible, my lord.
And
It is beyond the stipulated time, my lord.
No,
in
no,
the
no.
same matter,
Section 37, my lord.
Is 37. Oh, okay. So we have fixed that matter.
in the
We-
same matter,
let's
my lord.
Just wait. There are other matters which are there listed. We will look into that. This is that 37 beyond 60, beyond 60 days, no?
60 days, 60 days.
We will see. Pass over.
First. 11. Serial number 11.
Similar issue as serial number 10 minutes. Limitation is an issue,
We'll come, we'll pass over.
please.
12. Shilpa Shah. Serial number 12.
Just pass over.
Lordships, in the afternoon, I have some difficulty. There is 2:30 matter.
Let's see if it comes.
I'm
13 urgent. 14. Serial number 14.
My lord, I appear for the respondent.
Award has been dismissed. Award is dismissed and appeal is also dismissed. Now I am before the claimant is before this honorable court. LCR may be called for, my lord, and I will.
No, award has been dismissed
My lord, the
Oh,
claim petition filed
petition is dismissed. Claim petition is dismissed
by the arbitrator.
by the arbitrator.
Ah.
And my 34 is also unsuccessful.
Yes, now
Okay.
what do you say?
Claimant is before this.
What do you say?
The reason for dismissal of my claim petition is that learned arbitrator has, it is a construction work of railway parallel level crossing, pushing the boxes. That is the work. But during
Just will pass over.
no, my lord, you lordship may kindly see that
Yes,
these records are not here.
we'll see that. We'll see that.
I'm
Yes, yes, pass over.
15, Shri Venkat Subbarao.
Respondent, my lord.
Pardon?
Pay for the respondent.
Can you pass on,
Pass over,
please?
pass over.
16 withdrawn. 17, 14%. 17.
And for the appellant, my lords, in OS 1848, I mean, MFA 1848 and MFA 1847, and the respondent in the connected matter, my lords. I'm being led by Mr. Nandakumar in all these three matters, my lords. They all arise out of a common arbitration award.
You appear for whom?
I appear for, my lords, Northern Trust Operating Services, the appellant, my lords, in MFA
So there are
1848.
cross appeals, huh?
Cross appeals, my lords. They arise out of the same arbitration award. I am, my lords, agreed by my counterclaim being dismissed.
His claims being allowed.
His claim has also been dismissed in the arbitration award. What has happened thereafter, my lords, is that the
Why
section
did you
34
file two
court,
appeals?
the section 34 court, my lords, allows his 34 petition, but dismisses mine, saying that, my lords, the scope of the arbitration agreement does not include my counterclaims, which is incorrect, my lords. I have pointed that out in my MFA. I'll need.
But he has allowed his claims.
The 34 petition has been allowed. The award, my lord, has been dismissed. His claim petition has been dismissed in the award. Therefore, my lord's matter might have to be re-arbitrated for his claims to be awarded. I'll point out, my lords, I'm being led by a senior.
We want to know from you also, what is the position of law when the 34 court is exercising jurisdiction under 36? Can the court allow the claim petition, or the jurisdiction is limited to set aside
Please, my lords.
the award, or something more it can do it? Now, in this case, let's assume what will happen. It can, his claim petition having been dismissed, the court can still say set aside, but it will leave it at that, to say that you will work out the remedies under the contract, seeking a fresh invocation under the Arbitration Act. You must also look into it.
Yes.
You're getting the point? Or the 34 court say, look here, these are the claims, these were rejected. Now I will exercise, not under 34, as an original arbitrator would have done it, and allow the claim petition, allow the claims. Must look into the law. To the extent possible, the position of law is this: set aside or dismiss. Nothing more.
Please.
The 34 court cannot take upon itself and decide the claims afresh. It will say the parties would be at liberty to work out your remedies under the contract. You will invoke the arbitration once again and go back pressing your claims.
Please.
That's all.
I bow down to that, my lords.
You file your submissions.
Sir, 14%.
Yeah.
I need to make my arguments, if you can allow me to do so, sir.
No, we want to know this also from you.
Yes, sir.
Would you be ready to make your arguments on this?
Yes, sir. Sir, what is presented is half-baked story.
My lords,
So if I can inform the court what exactly is the matter, the background of this case, probably we may look at it from a different angle.
Pardon?
We may look from a different angle. So I have prepared this petition in person with all my research, whatever little knowledge I have. So if you can grant me some time, I can go through these arguments and then you can take a call, sir.
You give a copy to him also?
Yes, I have a copy, sir.
Just give it to him. You file it in the registry also, whatever you are filing it.
Yeah.
Okay? Just say this, the Mr. Jayaprakash Krishnaswamy Naidu,
Yes, sir.
the appellant and the respondents in MFA 403522 / MFA 184721 and MFA 1848 of 21 has handed over a copy of the written submissions prepared by him in all the appeals,
Yes, sir.
in all the
My
appeals.
lord, this is MFA 4035 alone.
Right, but
what
it
I've-
includes everything, sir. It includes 1847 and 1848 as well.
Let the counsel appearing for the other party, that is Northern Operating Services Private Limited, shall also file his submissions within 3 weeks. Re-notify the appeals for hearing on.
My lords, there is an interim order operating in my favor in 1848, my lords, staying the operation of the 34
Interim
court.
order in
MFA 1848.
FA 184821, if any, shall continue till the next date of hearing.
Please.
One more submission. Ravi, in one of the appellant Ravi H. name may be deleted. Counsel.
Okay.
In 4035.
Just say that since the appellant is appearing in person in MFA 403522, the name of HK Ravi HK be deleted
That also, my lords.
as the counsel for the appellant
Yes.
in the said appeal.
My lords, the cause list shows Mr. C.K. Nandakumar's name still. He's now been designated.
Yeah, right. Full stop. Further, who has filed the wakalat?
I'll file a fresh wakalat with all the my
Further, on so and so, what is a good name?
My name is Sham Harindra, but my lords, my colleague, Mr. Raghuram Kadambi's name may kindly be reflected.
Just say that the learner counsel for the Northern Operating Services Private Limited states that Mr. Raghuram Kadambi shall file his wakalat in MFA 1847 and 1848 of 21.
Please.
Full stop. On such filing, the name of Mr. Nandakumar C.K. as the counsel for the said appellant be deleted from the cause list. 18. Give the date, ma'am.
20th January.
Please. Grateful, my lords.
Serial number 18. Serial number 18, Srimati Kavita.
Yes.
Section 37 appeal. I was the successful claimant in an arbitration against a respondent. I was a service provider. I am a heritage consultant. I restore heritage works. That is my skill expertise. Respondent is the Mysore City Corporation. There were a couple of dilapidated heritage structures in Mysore for which tender was floated. I was a successful bidder. I was tasked to provide heritage restoration services for those two structures. Things went wrong. Some portion collapsed. I say it is not my fault. MCC said, the corporation said it is my fault. We went into arbitration. The learned arbitrator found that I am entitled to some compensation and damages. That has been awarded. So the arbitral award was in my favor. There were two structures, two arbitrations, both before the same arbitrator proceeding simultaneously. Thereafter, Section 34 was filed by the corporation. In Section 34, the district court thought it fit to interfere and set aside the award to the extent of compensation, etc. Therefore, now I am in appeal before this honorable court. Before we get into the merit, I was just giving the context. I am not, as of now, on the merits. While filing the appeal, amongst the advocates, the persons handling the filing of the Section 37 in the High Court, the advocate was not the same who was the advocate in the trial court. He filed one appeal thinking that the second certified copy of the order is a copy of the same and did not realize that there are two separate appeals to be filed. So he filed the first appeal. There was just a day or two's delay because the party is in Bombay. Filed the first appeal. When that appeal came to be listed, we realized that there should have been two and there's only one. And then realized that this is the lapse on the part of the advocate and that believing that it is a certified copy of the same order and not that there are two separate appeals, the second appeal was not filed. As soon as that matter was listed, within a couple of days, the second appeal also came to be filed. Consequently, now there is a 2 days delay in the filing of the first appeal. and about 70 or 80 odd days delay in the filing of the second appeal. I have to now persuade this court, A, that an appeal, delay in filing an appeal under section 37 is capable of being condoned. And then on the facts of the case, whether the condonation is permissible or not. This matter, I believe, was heard briefly on the last occasion. May I just take my lord through the case laws? My endeavor will be this, and I'll keep it short, that section 37 appeal delay can be condoned. If that is first recognized by this honorable court, that that power is available to the court, then we come to the second issue. Because if the court believes that that delay cannot be condoned, there is no such concept.
But little window for condoning?
There is whether there is a little window or not, easy question.
That's right. We'll do one thing. We have just passed over 2 more items.
Yes.
We will also just pass over so that we can hear all the counsels on this.
Very well.
Just we'll come back.
Very well. Noted. In fact, I prepared a compilation of case laws along with Borse brothers, others.
It's need to be decided, although Supreme Court has said so. We are in under Commercial Courts Act also.
That's
under 13(1)(a). Then we have 37 also. Very interesting.
Correct.
We have seen 37 independently being filed under 37 without being resorting to the provisions of the Commercial Courts Act.
Correct.
Now, there is no limitation there.
That's right.
For filing 37.
That's right.
People are resorting to the limitation,
under Limitation Act 116 and 117.
117.
That
gives a window for
90
days.
90 days.
From trial court to high court.
More than 60 days, which is permissible here.
Commercial court.
How would you reconcile?
That's right.
That's the issue.
And on that, and I'll just leave it. I'll make my submissions when we come. Not every matter under section 37 is necessarily a 31A also. There can be 37 appeals where primarily the relationship between the parties may not be a commercial transaction or may not be a commercial dispute. That distinction is also drawn in Borse brothers.
You're right. If it is not a commercial suit,
90.
The dispute is not commercial, though arbitrable.
Correct.
And 37 comes, it may not be under 31A.
That's
31.
That clarity. Great. We'll wait for the matter.
19 adjourned. Seal number 20, Joseph Anthony. 20.
The appellant in this matter. My lords, yesterday we had indicated that we could explore a settlement. We were.
But I'm sorry, my lord, there is no such thing. Seal number 20.
20.
What is no such thing? No terms?
No.
Given?
20 is where?
Okay, sorry. 20 is not. Sorry, my lord.
Yes, what do you say?
Lord, we are exploring, we are trying to.
We
have agreed on.
We have agreed.
What is this? We were given impression that just we are giving you another 5 minutes, we'll give them terms.
Please.
It's almost.
The officer. Where is the officer?
Lord, I'll.
See, the impression we are getting is only you wanted to take adjournment yesterday. Simple.
Oh, Lord, we have made efforts.
Where is the officer who had given the instructions?
I'll.
This is not the way. And the officer comes, he say he doesn't have terms. It's just off the cuff. Let's take an adjournment on this ground. That's the impression we got now.
My lord, we have sincerely made efforts, my lord. We have.
What sincerely? Tell us between the last day and this day, what efforts you have made? Tell us. Maybe bona fides are with you. But what is at least you should have at least tell her the figure. How can there be a settlement without telling her the figure?
My lord, if I may intervene, my lords, one figure they've given me, and yesterday in the evening, my lords,
Then
we
why
are
have
now
we given
stuck.
this impression that no figure was given?
Please, my lords, if I may mention, we are stuck on 3.5 lakhs, my lords, now. And they are just saying they want 4 days time to confirm if 3.5 lakhs can be repaid. And 2014, I booked the apartment.
What is your figure?
My lords, I've only requested for closure of the bank loan and for reimbursement of my booking amount of 14.5 lakhs. Plus 3.5 lakhs is the pre-EMI amounts, my lords. 14.5 lakhs, they've agreed to reimburse. Bank loan, they've agreed to close, provided I forego my interest, claim of any interest whatsoever on the booking amounts. I'm insisting that at least the pre-EMI amounts may be reimbursed to the party.
No, are you agreeable for them to clear the bank loan?
Please, my lords, I'm agreeable on that.
Whatever is the amount there, that will be worked out by the bank.
Please, my lords.
And for them to pay you the booking amount.
Please, my lords.
You are insisting on interest.
I'm not, in fact, the party is all right with the interest, my lords. However, whatever he has incurred with respect to the EMIs which he had paid to the bank, They had undertaken to repay it and they have repaid a portion of it, 3.5
Yes.
lakhs maybe.
My lord,
What is the figure given to them?
honestly, my lord, they have interacted.
The
But no, it appears that it is reaching a final. I'm very happy about that. So probably they are seeking for another small last item.
lakhs.
3.5 lakhs. I think that also would be solved. In fact, I already advised my client to clear
This
it.
3.5 lakhs is on the interest you have paid to the, on the
Please,
the
my lord.
loan amount
Please, on the loan
for
amount,
the past period.
for the past period.
That I'll advise them to clear it.
Onus
Because
was
they
on
have
them
so
to
far
clear
they
it.
have come.
You saying so that you have told them to
No, I
clear
will
it?
advise them. Just now, madam told me outside.
Very well. No, if you then very well, we'll pass it over, get your final instructions.
My lord, may I request, Nale itkolona?
Pass over.
No, pass over because I will be in a trial right now. Therefore,
We'll have it tomorrow.
tomorrow.
Tomorrow would be fine.
Please, madam.
So we understand this. You will clear their loan account
Please, madam.
for the future period. There is a booking amount given by her, given by them. And you would pay them, repay
3.5
that
lakhs,
amount
that's all.
also. May not be interest on that amount.
Please, madam.
Interest he has given, paid to the bank for the past EMIs.
Very well, my lord.
That's right.
Please, please.
Or
my lord.
may I request my learned friend to give a memo of
You
calculation?
do
so
one
that-
thing, just give it to him so that he has a clarity on it.
Please,
Yes,
my
madam.
lord.
So that I will
will
be
have
able
it.
to interact with my client. madam.
Okay, just say that at the joint request of the council of
Madam,
the
this
parties
one memo
re-notify
could
tomorrow.
be memo.
We'll have it tomorrow.
Well, may I request a letter, my friend, give me the memo of calculations. I will furnish it to them.
He will broadly give you
Very well, madam.
what she is agreeable to you or
Very
what
well.
you should do it.
Very well. Yes, madam.
The loan, repay the loan, pay the
Very well.
booking amount and the interest component which he had paid for the previous EMIs.
Very well. Around 3.5 lakhs, what she says. That would prevail better.
You tell the amount also, he
Please,
should know.
I have the calculation. my lord.
Yes, thank you. Next.
Oh, yes.
I'm grateful, madam.
Serial number 21, Shri Siddhamalappa.
Appellants, my lords, weeks of time may be granted, Your Honor.
Why, ma'am?
A senior has undergone eye surgery, my lords.
Who?
Sid Malappa, sir. Weeks of time may be granted, my lords.
Say that the counsel is said, the arguing counsel for the appellant is said to be unwell or said to be in unwell. Just say that. You say in personal difficulty.
23rd January.
Oblige, Your Honor.
Short date suit for recovery of money.
We thought we could have.
Yes,
heard.
ma'am.
Let him come back.
Yes, ma'am.
Serial number 22, Shri Manu. Serial number 22.
Appearing for the appellant, my lords, I seek 2 weeks accommodation. The senior who's been engaged in this matter, there's some inconvenience today. For that reason, I pray for just 2 weeks' time, my lords.
What do you say?
It may be adjourned.
The request of counsel for the appellant re-notify.
24th January. Serial number 23, Mahesh.
Appear for the appellant in this matter. Responding. My lord, I seek for an adjournment in this matter, my lord. But I was led by a senior, my lord. Senior can no longer appear in the matter because he is now designated as the ASG. Would it be called after 2 weeks, my lord?
Is it a date given matter?
No, my lord.
Not.
It's not a date given.
Just say the
I have
request of
just
counsel
one
for the
submission.
appellant re-notify.
Please, I'm filing my wakalat today, my lords. My seniors may be reflected. The second aspect, my lords, is the award under challenge. According to us, stands satisfied because I've already paid the amounts due. In that light, may I request the shortest possible date subject to this court's calendar?
It's just say that the so-and-so appears for the respondent states that he shall file wakalat within 1 week. Re-notify on.
Seventeen 12,
Grateful.
Next.
serial number 24, Shri Bipin Hegde.
To the respondent, Lord. This matter was listed yesterday, Lord, if Lordships wanted to, Lord, we to file the memo of calculations.
My lord, may I make one request, my lord?
So-
I'll also file my synopsis, my lord, along with the memo of calculations. According to us, what is due to them has already been paid after the appeal has been filed. After the appeal was filed, as per the interim order directed by this court, my lord, we had paid 10 lakhs. Subsequently, my lord, we made a statement, my lord, we are due another sum of 8.5 lakhs. totally 18.5 lakhs has been paid. That is the balance of amount, my lord, towards the rent and electricity charges. Therefore, my lord, even I will file a synopsis along with my statement of accounts, my lord, if a date is given, my lord.
How much you paid after the decree?
My lord, total is 18.5 lakhs, my lord.
How much?
18.5 lakhs.
18.
18, 18. my lord.
As against
No, but
87.
according to them, it is 87.
That is what they claim, my lord. My
So
case,
that much is the difference.
that is the difference, my lord.
Huge. I think we better go very well.
Please,
File your calculation.
Yes, my lord.
The council, ma'am, you file it e-filing. Just give it back. Let him file e-filing. The learner counsel for the respondent states that she shall file she shall file calculations as to be payable by the appellant to the respondents. To the respondents or all the respondents or one only?
there are
Two
two respondents,
respondents.
the other party has been placed,
Has been-
deleted in the, before the trial.
To the respondents 1 and 2. That's right, 1 and 2.
Yes.
Yes, Lord.
The learned counsel for the appellant states that he shall also file his calculations.
That-
Full stop. Let the same be filed within 4 weeks, re-notify on.
But may I make one submission, Lord? The only dispute, Lord, in this case, Lord, is when did they vacate the premises? In their written statement as well as, Lord, in the evidence before the trial court, they have said, Lord, it was in March 2021, though we are disputing that. Till that date, if we calculate the rental, it will be around 35 lakhs. Rental alone.
I'll file my synopsis. My lord,
From Lord, delaying the process, Lord.
Is not disputed.
rent is not disputed.
is not
Rent is, my lord,
Will be clear, ma'am, let them file.
yes, my lord,
But
if I may submit.
16 lakhs or 18 lakhs, Lord, it has no connection. Even the rentals alone would come to 35 lakhs.
My only submission is that, my lord, this matter, my lord, the trial had conducted, my lord, during the time of COVID. We had, my lord, produced the documents by way of CD, which was marked as Exhibit D1. This Exhibit D1, my lord, was not looked into by the court below because, my lord, there are several documents, my lord, which were in the CD. None of the documents, my lord, were looked into it. Because, my lord, there are documents there to show that we had returned mails to the landlord saying that we have handed over the possession and this is the date of handing over possession. My lord, by going through the orders passed by the court below, it can be seen, my lord, nothing is there, my lord, with respect of D1, which has more than 10 documents. If the court below, my lord, had looked into this Exhibit D1, my lord, then the matter would have been, my lord, at a different color. That is what I could submit. Now, my lord, I will also file a paper book because along with these documents, because Exhibit D1 is just a CD, for this honorable court to look into the documents, my lord, those also will be required.
Lord, may I submit, Lord, on this CD aspect? Like the Evidence Act, Lord, requires the copies of the documents to be, Lord, placed
Since
before
we-
the court and the originals should be
Let them
placed.
file, let both of you.
Lord, reappreciation of facts, Lord, would be, Lord. So placing
see.
the documentary evidence
We
before
will
the
see,
trial
ma'am,
court.
we'll see, we are in first appeal.
Yes,
We'll see.
ma'am.
Please.
Next, 25.
17th January, sir. Serial number 25, Shri B.C. Venkatesh. Madam, 17th January. 25, Shri B.C. Venkatesh.
For the respondents. Lord, there is a small inconvenience. Even the appellant has not been present. Case may be-
Appellant?
Appellant has not been present. The case may be adjourned, my lord.
Yes, yours, ma'am. Was anyone present? None for the appellant, re-notify.
24th January.
Great.
First your matters. Serial number 1. Hush, be checking.
Respondent, my lords. Your Lordships, I am appearing for respondents.
Serial number 1, madam.
Yes.
LM wins,
We
Your
need the
Lordship.
counsel here. Who appeared in the morning. Just pass over.
Serial number 3. Serial number 3.
I appear for the appellant. Lord, I have gone through the papers available with me. This is with regard to the, my lord, the plaintiff, the appellant was a plaintiff before the trial court. And she had filed a suit under section 34. The facts runs like this, my lord. She was appointed as a agent by the the respondent. Respondent was a sharebroker member, and she was appointed the agent under under them, and she was entitled for remission fee and also the as an agent's commission as such to discharge her duties during the period 2009, that is 1/4/2010 to 31/3/2011. Her professional fees regarding the agent's fee as well as remission fee was not paid. However, the respondents deducted in their accounts, they have shown it as an amount due and made the TDS also tax deduction at source under the Income Tax Act and paid it to the department. It is an undisputed fact. Now, my lord, the notice was issued by the appellant for claiming that amount which she has not received through her husband. He was a chartered accountant. Through her husband, she sent her notice, for which they gave a statement of account also. And also in that statement of account, it was clearly shown as this amount of professional fee was payable to her, and TDS was also made, that has been shown. Thereafter, when this was taken up, because they are governed by the National Stock Exchange rules and regulations, the dispute was taken before the National Exchange, my lord, for referring the matter to arbitration. The National Stock Exchange referred the matter for 3 arbitration
grounds for challenge.
Challenging, my lord, these 2 grounds, my lord. One is that though there was account, so there is no written agreement between the plaintiff and defendant.
What is the period for which the amount was being claimed?
1/4/2010 to 31/3/2011.
1/4/2010
to 31/3/2011.
Now, when did you first raise the claim?
Well, in this scene, the claim was made. Date of claim is not before the arbitration.
Okay.
Okay.
No, before the arbitration.
It is in 2011 itself, my lord.
Very well. 2011 you made.
Yes, madam.
Now, what are the grounds? If you see paragraph 16.
16 grounds, my lord.
Hmm.
Yes. From the above decision of the Honorable Supreme Court is very clear that the grounds, my lord, yes, that the impugned award is required to be set aside. The same is against the public policy of India and against the justice and morality and in contravention of substantive law governing the parties. Any agreement between the parties do not enter certain acts for certain consideration may be either written or oral. Even oral agreement also legally enforceable. From the pleadings of the parties, in the instant case, no doubt the written MOU or arrangement did not come in the existence to establish to authorize the persons trading members till 3/9/2010, on which date the NSC has recognized the appellant has authorized the person of defendant. However, the fact that she has worked as authorized agent and provided services of procuring clients, etc., to the trading business of defendant from 2008, 2009 to 10 and 11 was not denied. The said facts fortified from the admission made by the respondent in their statement of account maintained in their usual course of business by showing entries regarding the amount due by the appellant as well as the TDS made by them and remitted to IT department towards the said due. In these circumstances, there was sufficient material as per the law
and decisions rendered by the courts in number of case litigations to conclude that appellant was an authorized agent and a defendant in its trading business during the relevant time. The respondent, however, did not dispute the said entries made out relevant time, but to avoid its liability, totally removed the said entries and produced the subsequently manipulated the statement of account to suit their claim before the honorable arbitrators, when they have not denied the earlier entries made as amount due to the appellant and made the payments towards TDS. The same was sufficient for the honorable arbitrators to allow the claim of the appellant as per law, that the learned civil judge erred in appreciating not, it should have been not appreciating the fact in proper perception. What has happened, my lord? This there was an agreement was supposed to be entered into between the agent and the broker, sorry, share member. Then, my lord, this agreement for certain reasons it was not concluded and not executed. However, on 3/9/2010, the stock exchange also recognized her as a recognized agent under the respondent as a stockbroker. So there are two parts, my lord. From 1/4/2010 to 1,000, sorry, 3/9/2010. There was no agreement, I agree, my lord. From 3/9/2010 up to 31/3/2011, my lord, there was an agreement.
Agreement between whom?
Agreement between plaintiff, not agreement in the oral agreement, my lord, that was recognized by the stock exchange. That's the reason they have referred to matter to arbitration. If there were no agreement.
You have submitted to the jurisdiction of the arbitration.
My lord, the arbitration, because they have sent it to the arbitration, we have sent it.
So you appeared before the arbitrator.
Yes, arbitrators who have appeared.
You filed before the appellate tribunal also.
Yes, but there also it is filed, unsuccessful.
Now, which is the ground you are saying?
No,
the only ground it appears to.
Appears on merit is this.
On merit.
On merit, this is the one, my lord. The second one, my lord, the civil servants.
Say.
Yes, ma'am.
Procedure, you say they have not informed you about the procedure.
No, that's my lord.
Then you say that failed to consider documents in support of the
yes, my lord, that is a failed support means since, my lord. The account extract was very clear. Regarding, I have filed a memo also along with the trial court also saying that what is the amount due for the after 3/9/2010 up to 2011, my lord. So those memo was not taken into consideration by the arbitrators. Arbitrators could not have given at least from that date when they say, my lord, arbitrator.
But where is the memo?
In the trial court I had filed it, my lord. Trial court it was filed along with the memo. And in
you have not filed it.
Not here. Here along with the memo, I filed the copy of the statement of extract, my lord, that has been filed before the arbitrators, wherein that 1/4/2010 to 31/3/2011, the different periods are there. It could have been given at least, there comes to $8,68,718. That could have been at least to that extent, but out of
how much?
Out of 48 lakhs that was claimed. My lord, a sum of rupees 8 lakhs in dollar. I'm sorry, 8. Memo, my lord.
We'll call for the record.
Yes, we call.
Is the record here?
Records.
My lordship, by order dated June 2023, the records have been secured. They're before the court.
Where is the memo? How would you refer to this document when you don't have this? You must have this, no?
That's the reason, my lord, I didn't have that file and also could not go through.
No, how would you refer it? Unless and until you refer it, you see it, you can't refer all these things.
That's the reason I request a short recommendation so that I will get ready and back in order.
Just say the request of counsel.
My lordship, with my lordship's permission, my submission is that none of the records from the courts are required. Just the MFA may be decided on the basis of the paper book, because the primary submission is that it's not maintainable before this court.
Why?
The section 34 court rejected the petition filed under section 34 on the ground that it has no jurisdiction.
Why? It
The
doesn't have
arbitration proceeding was held in Chennai. The claim was filed in Chennai. The arbitral award was passed in Chennai. The appeal from the arbitral award to the arbitral panel was also in Chennai. So both awards were passed in Chennai and a section 34 has been filed.
Where was she operating from?
She was operating from Bangalore. There's no doubt, my lordship. I don't doubt today there's a cause of action in Bangalore. Both parties submitted themselves to the juridical seat in Chennai. Now, when the arbitral award was rendered, it was very clearly specified in the award, even a section 34, if filed, has to be filed in Chennai. Now,
The agreement says so?
the tribunal says where it is signed and dated, my lordship.
What?
The bylaws of the NSE, which provide for a section 34, specifically say that where the arbitration takes place.
These bylaws are there?
My lordship, it's there in the impugned judgment itself, if I just may point it out. In fact, my lordship, this exact same question that is before this court has already risen before the Supreme Court. A full judge bench has held that today a 34 is not maintainable. And when a 34 is set aside on the ground or disallowed on the ground that there's no jurisdiction, a 37 is not maintainable from a judgment on jurisdiction. That is a clear proposition of law. If my lordship will come to page number.
Application under section 34 is pending against the decision of the appellate award. Asked by the appellate arbitration will be filed in the complaint nearest to the address provided by the constituent. Who is the constituent in?
Constituent is the appellant. Appellant.
I am the trading
What is-
platform.
What is your address in the KYC?
No, it was given in the, this thing as Bangalore only, my lord.
That's there in the impugned judgment at page number 48, my lordship. It's there. Chennai is the address which is provided.
Chennai, the address in KYC?
Yes, my lordship. It's recorded in the 34 judgment. If my lordship comes to page number
Why
40.
does he go in merits of the case?
Only on jurisdiction, my lordship. The same question which arose as to why the parties were in Chennai. Now, the KYC form provided for Chennai, which is why she filed her complaint with the NSE in Chennai. She filed her claim statement also in the Chennai arbitration panel. I'll just read out one paragraph, my lordship. If my lordship has page 48. Para 35. Plaintiff herself laid her claim before NSE contending that she is the authorized agent to the defendant and she was appointed as remissor. Under such circumstances, she can agitate her claim under NSE bylaws only. Accordingly, she filed her claim before arbitral tribunal of NSE. According to the bylaws of NSE, the clauses are right on top of this paragraph. Arbitration proceedings were held at Chennai Regional Center nearest to the one provided by plaintiff in KYC. Clause 19C specifically states that a party aggrieved by the appellate award may file an application under section 34 of the Act before the court.
Come to para 23.
Yes, my lordship.
Read it.
Further contention of the plaintiff is that arbitral tribunal has failed to consider the documents in support of the claim. Since the contract regarding the authorized agency of the plaintiff was between the defendant and the NSE, NSE should have been summoned. On perusal of the records of arbitral proceedings, it is clear that arbitral tribunal referred to various documents that were placed before it. Plaintiff barely contends that arbitral tribunal has failed to consider the documents filed in support of her claim. She has not made specific that where the documents which ought to have been considered by the arbitral tribunal and that if the same were considered, the award would have been different. Even she has not made any cursory reference about the documents in her plaint, which were to be considered by the arbitral tribunal. Moreover, she has not taken any such contention or brought to the notice of the appellate arbitral tribunal that arbitral tribunal has failed to consider the documents provided by her. In this background, it has to be said that there is substance in contending that the arbitral tribunal has not considered the documents in allowing the claim of the plaintiff. This is not a finding of the court, my lordship.
We don't know. It appears to be.
My lordship, in that case, I'll read out a couple of more paragraphs from the judgment.
Then why is he discussing associate builders and all those things?
That is all on jurisdiction, my lordship. There were two questions framed by the court.
Inherent lack of jurisdiction or limitation in exercising jurisdiction are two different things. Getting?
Yes, my lordship.
Your argument is inherent lack of jurisdiction.
The 34 could not have been filed before this court.
That's right. Not under 34, limited jurisdiction.
I bow down.
That's
I
the
bow down.
difference.
If my lordship sees the points of determination on page number 23, there are two questions framed by the section 34 court. The first question is whether this court has jurisdiction to entertain the present suit. A finding is returned on this specific question towards the end in the operative part of the judgment.
What do you say on this?
There's a reason, my lord. There are 2 points involved. One is regarding the merit of the case, another is the
No, merit
point
of the case,
jurisdiction.
although
Yes.
he has said so, but ultimately what he does says is,
Kindly, I request the lordship to kindly see, my lord, section 2E of the definition, my lord, court.
the difficulty is,
Court.
that's the whole problem.
Court.
He has missed out the whole point. And see what is the conclusion drawn by him?
There's no jurisdiction.
No, for what reasons?
So point 1 and point 2, on point 1, he holds specifically on my argument that there is no jurisdiction.
Now see the order.
Yes, my lord. I do bow down, my lordship, as an officer of the court. There are findings returned not just on jurisdiction,
Even
but
on merits.
also on merits.
That's how he confuses himself.
I bow down. I bow down
Only
completely to
confined
this.
himself to only one point. Look here, I have no jurisdiction. I will not go on merit.
I bow down. Now, what happens in most of these cases, my lordship, I submit, assuming the court has jurisdiction on merits, they are not to succeed, and which is what the court does.
But he has
I bow down.
framed for his consideration the issue of jurisdiction.
I bow down. As an officer of the court, both has been done. The question here is slightly more limited, my lordship. Today, in section 37, is this maintainable or not maintainable? This is squarely covered by a 3-judge bench decision of the Supreme Court. There are paragraphs which also refer to what my learned friend is about to submit. The definition of court under section 2 is not read as divorced from the place of arbitral proceedings under section 20 and section 31. The minute an award is drawn up in a specific place, which is Chennai, the juridical seat is equal to the exclusive jurisdiction clause. The exact same fact situation as
There
it
is
is.
no dispute, there is no issue on that. Now the fact remains the court below goes on merits.
It appears so, my lordship.
And the ultimate order is keeping in view the limited jurisdiction on 34.
My lordship,
order?
if I may read the award, the meaning,
Get the award, see the order,
the order.
page 52.
Suit
Suit filed
filed
under
under-
34 is to set aside the evidence.
No, the operative portion there is to set aside. It's been dismissed, my lordship, but the finding, the operative reasons are all there in the penultimate paragraphs, which are a holding on jurisdiction.
So you want us only to take jurisdiction, not on merits. He will go to Chennai court will say, look here, there is a conclusion against you.
My lordship, it may be taken up on merits as well. My preliminary submission is on maintainability. Today that everything was done in Chennai, this court has no jurisdiction to hear it because the 34 court, the operative part, the principal reason why it's been rejected is because the 34 was filed in the wrong jurisdiction. Even if it is being heard on merits.
He goes to Chennai, let's see. Chennai court will say, look here, there is a determination on merits also by the court below. I can't do it. I can't set aside. Because that's beyond that jurisdiction of that court. How would you answer that?
My lordship, the findings of the 34 court here will not bind any 34 which is potentially filed in Chennai.
Today, he is going against the judgment passed by within the jurisdiction of this state. He goes to Chennai. There is a determination on merits and even on the jurisdiction. Very well, jurisdiction. Let's assume we relegate him to Chennai court.
Yes, my lordship.
Now, what will be there before the Chennai court? The determination on merits.
By the section 34 court here.
By the section 34 court. Can the Chennai court set aside?
No, my lordship. The Chennai court has no
He will be
jurisdiction.
neither here, neither there. Unless and until we say that the Chennai court has the jurisdiction and he should file it, that determination shall be without being influenced by the observations or conclusion drawn on merits.
My lord, this is
I bow down to that. I bow down to that, my lordship. Generally, in a section 34 court, my lordship is right. Even in the 2019 judgment, the application which was returned by the section 34 court was returned with liberty to file in the appropriate jurisdiction. Now, that has not been done by the commercial court. Yeah.
He should have said so.
I bow down. I bow down.
Rejected,
I
he
bow
should
down.
liberty there.
As an officer of the court, I bow down, my lordship.
Stated in my ground number 9 also, my lord, that is ought to have been rejected. Suppose if he is found that.
But tell us one thing, in terms of that bylaw, The jurisdiction lie before the Chennai court.
No, that's bylaws, my lord, that the judgments based on my learned friend is submitting, my lord, is based on the agreement between the parties when the parties choose place, etc., etc. But here is not an agreement, it is by statute, the arbitration has been.
But where did you invoke the arbitration? Where did the arbitration
National
held?
Stock Exchange from Bangalore only. Bangalore, she is resident of Bangalore and she is working place also at Bangalore. She's raised the dispute from Bangalure.
What about the KYC
They
details?
appointed the arbitrator, my lord.
KYC details.
KYC, I'm told, my lord, the form is not available, but in the name, everything for address given is Bangalore only. And the form, no, I don't have, my lord, right now. Where it is.
And who referred the arbitration to?
National Stock Exchange.
NSE Chennai, my lordship.
NSE Chennai.
The grievance redressal cell, she wrote a complaint to the grievance redressal cell in Chennai. NSE Chennai cell responded to her saying that this has to be arbitrated with your KYC platform documents, which is in Chennai. So she filed her complaint and her statement of claim before the arbitral panel in Chennai.
No,
KYC details says Chennai.
Yes, my lordship.
One submission.
How do we get that? Just see, ma'am, just show us the file. Or yes, show from the record the KYC details.
Yes, my lordship.
My lord, it is, may I make one submission, my lord?
Yeah, yeah.
The defendant is a resident of, having a registered office at Mumbai, my lord. The respondent, I'm sorry, so plaintiff is having its franchise office in Bangalore. Their office at Bangalore, they have got a branch at Bangalore.
Whose office?
The defendant's office at Bangalore. She was working under them as.
Okay. She was working?
In Bangalore as agent.
Very well.
Yes. My lord, both were, one is Mumbai, one is Bangalore. The dispute was raised with the National Exchange at Mumbai. And then it was referred to National Exchange, the local, their local, I mean.
But tell us, why was it not referred to Bangalore?
No, their office is not here. That's the reason that, the reason wise, they have Madras and Madras.
They don't have here in Bangalore.
National Stock Exchange, at that time it was not there. That is the reason they have referred to South in Mumbai, sorry, Madras.
No, but your KYC details says Bangalore.
That one I'm not.
My lordship, the KYC details are Chennai. I'll find the document. The section 34 court also records that it's KYC in Chennai.
This is very unreasonable clause in the sentence. You're driving her there nearly because
I don't doubt it at all, my lordship.
But if her KYC details shows Chennai and the basis for jurisdiction is primarily based on those details. Say, if any, against the decision of the appellate passed by the appellate arbitrator shall be filed in the competent court nearest to the address provided by constituent in the KYC form or as per the change in address communicated thereafter by the constituent to the trading members. Now mind it, if it was Chennai initially, you shifted to Bangalore, see that scope they provide, but you must inform the NSC about the change of address. So that accordingly you are brought under the jurisdiction of the concerned NSC wherever you shift. Now check up from the KYC details.
I'll look at this, my lordship. My additional submission is, even if the KYC document is not on record, even if the KYC document is completely disregarded, the minute the arbitral tribunal draws up its award in accordance with section 31(4) of the Arbitration Act, the exclusive jurisdiction clause sets in.
Then we will read it to mean only a seat, not an exclusive jurisdiction.
My lordship, the distinction there has been struck down by the Supreme Court to say that.
We know what is the law, please. It's for a convenience sake because NSC was only there, not here.
It's not a venue in any sense, my lordship. It's a seat in all the senses.
I think possibly I stand corrected. It would be only a venue, not a seat.
My lordship, I bow down very much to this.
It's only a venue, not a seat.
Today, the question is, when the arbitration proceedings have in entirety been held in Chennai, evidence collected in Chennai.
Seat. It would still be a seat.
My lordship.
There is a judgment. There are many judgments. There are judgments also under the MSME. MSME is the council concern. The council concern refers party from one station to the other because the MSC council was stationed there. The proceedings held there. It was held that for the purpose, that is only for the purpose of venue. That's all. Seat would in any case, what has been agreed by the parties.
Yes, my lordship. In this, there's no agreed seat between the parties. There's no agreed venue between the parties. And the position today is, in the absence of a stipulated seat or venue, the drawing up of the arbitral award under section 31(4) determines not just the juridical seat, but also the exclusive jurisdiction.
Was there any previous litigation so as to get attracted, 42 get attracted?
There was no previous litigation between the parties. Which is why, my lordship, even the KYC form completely aside, the matter of fact is today, when you read section 20 with section 31(4) of the arbitration award, the party has submitted herself to the jurisdiction of Chennai. No dispute has been raised at any point of time when all the arbitral proceedings are taken place that this is not where the proceeding should be held. There's no application for change of KYC. There's no application to transfer it to Bangalore itself.
Let's see KYC form if she is there.
I'll have to look at this, my lordship. I'll just look at this in the meantime.
What is the finding on this by the court below?
My lordship, if my lordship comes to paragraph.
What does he say by noting this bylaw to say that the jurisdiction would lie before the Chennai court?
This is on from page number 48 onwards, my lordship. The relevant clause is at page 47, which I believe my lordships have read.
Yes.
If at page 48, I'll just read out paragraph 35 and 36. Plaintiff herself laid her claim before NSE, contending that she is the authorized agent of defendant and she was appointed as remissor. Under such circumstances, she can agitate her claim under NSE bylaws only. Accordingly, she filed her claim before Arbitral Tribunal of NSE according to the bylaws of NSE. Arbitration proceedings were held at Chennai Regional Center, nearest to the one provided by plaintiff in KYC. Clause 19, my lordship has already read this. Further letter addressed by BSE Limited makes it clear that plaintiff was intimated to file application under section 34 of the Arbitration and Conciliation Act in a competent court nearest to the Regional Arbitration Center, Chennai. If she is aggrieved by the arbitral award, relevant portion of the letter addressed to her is as below. Further to the exchange circular so-and-so dated so-and-so, in compliance with the SEBI directive via circular so-and-so, in case you are aggrieved by the appellate arbitral.
Come to para 37, page 50.
Having come to the arbitration clause in the bylaws, as per provision of the bylaws, the seat of the arbitration has been decided as Chennai. Other address provided by plaintiff in KYC, the address provided by the plaintiff in the KYC form, and it mandates the consequent appeal under section 34 of the Act shall be filed in the competent court nearest to the address provided by the constituent in the KYC form.
No. See, the line says the seat of arbitration has been decided as Chennai. The address provided by plaintiff in KIC form and it mandates the consequential appeal under 34 shall be filed in the competent court nearest to the address provided by the consequent. It is abundantly clear that the application under 34 against the appellate award should have been filed by the plaintiff within the nearest district court in Chennai. It's not all the case of he doesn't really says with authority that she has given the address in the KYC form of Chennai.
It is there in both these paragraphs, my lordship. It's not said in so many words.
That's what we are saying.
Even in 36, it says arbitration proceedings were held at Chennai Regional Center nearest to the one provided by the plaintiff in the KYC form. It's very clear, my lordship.
Yes. See, we don't want something which is contrary to the bylaw. Let's be very clear on this.
Yes.
Although he does everything, he goes on merits, he says everything, he invokes the jurisdiction, limited jurisdiction a court has under 34 and dismiss it. But in substance, the Chennai court would have jurisdiction. Possibly he would be right in saying so. And that's what even the court below holds, that for all purposes, the seat is Chennai, not a venue.
Lord, that's we got upon section 2E of the Act, my lord. That's the reason we filed it in Bangalore court, my lord.
Who?
2E of the Act.
Which Act?
That is the Arbitration Act.
Yes,
it defines court means under section 34.
Oh, that court means obviously need to be read
yes,
as the context of seat.
That's how we thought, my lord, it's maintainable here. That's the fact. So
Otherwise, it leads to confusion.
Yes.
See, the intent is this.
Yes.
Wherever the proceedings are being held, the court there should have jurisdiction, supervisory role or jurisdiction. Suppose you want to file section 9, you will go there. You want to challenge it, you will go there.
Yes.
And there is a 42 concept also. Let's not go into that. So proceeding being held, let's assume for a moment, arbitrator is in Chennai.
Yes.
Can a court in Bangalore exercise jurisdiction over the arbitration? Can't.
So we can't because
that's the intent.
But while defining in E, what has happened, my lord, where the suit, suppose based on the cause of action where it has arisen, that court, principal district court, judge have a jurisdiction in section 34, that is the reason, that is the confusion made in the file. Kindly see, my lord, court may, that has been defined in section 2E, my lord. That's the reason, my lord, it was filed.
I may just respond to.
That's the reason, my lord, it was filed, my lord, not intentionally it was brought and filed. May I read that section 2E?
Interestingly, does the first, how many appellate jurisdictions are there under the bylaws?
One, my lordship. There's a panel of 3 arbitrators. It goes on appeal to a panel of 3 arbitrators. Then it goes under the section 34 court. Now the arbitral award.
Where was the appellate tribunal? Appellate.
Chennai. Chennai, my lordship. Everything is taking place in Chennai.
Except 34 court.
Except the 34. And to answer my learned friend's submission, today, cause of action under section 2, this argument has also been squarely rejected.
But that in any case, that interpretation can't be given. Court means the court which has the jurisdiction.
Only read with section 20 and 31 of the Act. Because there is a dichotomy.
See, we can do this, although he has something dealt with merits also.
Yes, ma'am.
We can say that you will go to the court there, Chennai court. And the Chennai court will decide the issue on merits.
Yes.
Without being influenced by any observations of the 34 court on merit. You will be challenging the appellate tribunal and the arbitrator, the initial arbitrator award and the appellate tribunal award.
But one technical problem may arise.
And the period while you were pursuing this litigation would be excluded for the purpose of section 14.
But what's similar, the Supreme Court also says, it can't be even extended single even for 34 also.
Pardon?
34, after 120 days, it can't be given. That is the reason. Section 14 also.
You're right. You're right.
That's why
surely that section benefit of section 14 would be available. What is your take on that?
Because
my lordship, bona fide proceedings in litigation in a court of wrong jurisdiction are excluded.
That in any case we will do, but we can record his submission. He will not raise the point of limitation in view of the fact you are pursuing here.
My lordship, I will object to limitation in that court as well.
Will you?
If it's the period of from the date of the order of the 34 court till the institution in the 34 court in Chennai may be excluded. But if there's any question of limitation prior to that, that has to be kept open, my lordship.
Take that. We take that.
Yeah.
So the time between the time period when you file 34 till a decision or till our order here, granting you time within 1 week that you should file your petition there, we will exclude it.
I bow down, my lordship.
We need to exclude it. We'll give him some time.
I bow down.
We'll exclude it. But if you are already, your 34 would be hit by the limitation from the award, then that you have to suffer in the sense that will, whatever is the consequence. What do you say?
Yes, Mr. That is what I wanted to make a submission because on the merits it could not have done. And
we will say so.
Allowed
to say so.
The plaint could have been returned and for presentation.
Exactly, he should have done. Even he rejects it, he doesn't say so. That plaint be returned.
That is a policy of the judgment. I bow down, my lordship.
So just take this. The appeal has been filed by the appellant challenging the order passed by the court so-and-so. Whereby the court, the learned sessions judge has dismissed the appeal filed under section 34 of the Arbitration Conciliation Act 1996. First of all, it is no dispute that the appellant herein, who was providing business development and client introduction services as authorized agent
My lordship, it may be said as claimed. It will be read as a finding on merit.
There is no dispute, just don't say no dispute. It was the case of the appellant that she was providing business development and client introduction services as authorized agent to the respondent herein, who was running its trading in shares and securities as a trading member of the National Stock Exchange of India Limited, at its bracket NSE in short, at its Bangalore office for over 4 years. First up, some disputes had arisen between the appellant and the respondent. And in terms of the bylaws of the National Stock Exchange, the parties were referred to the arbitration under the bylaws of the National NSE. First up, arbitration under the arbitration consisting of three arbitrators. Three arbitrators?
Yes, my lordship.
Initially also.
Initially also three arbitrators.
Three arbitrators. Full stop. Suffice would it be to state that the arbitrators, they say arbitral tribunal consisting of 3 members, had dismissed the claim petition filed by the appellant herein. Full stop. Under the bylaws, since an appeal provision is provided, the appellate arbitral tribunal, also consisting of 3 members.
Yes, my lordship.
Dismiss the challenge to the award by the arbitral tribunal dated 22/2/2012. Full stop. It may be necessary to state here that as per bylaw
Page number 47, my lordship.
bylaw 17, page 47, you reproduce it, which provides for jurisdiction of the arbitration and appellate arbitration, stipulates that the application under section 34 of the Act, if any, against the decision of the appellate arbitral award passed by the appellate arbitrator, shall be filed in the competent court nearest to the address provided by the constituent in the KYC form, or as per the change in address communicated thereafter by the constituent to the trading members. It appears that the appellant herein had provided the address, her address at Chennai in the KYC form. This we say so in view of the finding of the sessions judge in paragraph 37 of the order, impugned order. The sessions judge had considered for it, had framed for its consideration 2 points. That is whether whether this court has jurisdiction to entertain the present suit. 2, whether the plaintiff has made out any of the grounds as enumerated in section 34 of the Arbitration and Conciliation Act 1996 to set aside the impugned awards. 3, what order. The point number 1 and 2 have been answered in the negative. And point 3, it was held as per final order. We find that the the sessions judge had insofar as maintainability of the suit is concerned, though answered in the negative by stating in paragraph 37 which we have already reproduced above. He has also answered the merits, answered the challenge on the merits of the case as well. This we say so because of the findings of the sessions judge in paragraphs 23 onwards. And at paragraph 23 onwards, between in paragraphs 23 hyphen (32) 32. Full stop. The plea of learned counsel for the appellant is that since the appellant is residing in Bangalore, she had filed the
Cause of action also.
would submit. Why the cause of action?
Because she's worked as a agent here and the amount was due.
The submission of the learned counsel for the appellant is that since the appellant had worked as an agent of the respondent in Bangalore, and she is also a resident of Bangalore, she had invoked the jurisdiction of the Bangalore court in challenge to the award oblique to the awards. Yes, say that to the awards of the tribunal, arbitral tribunal oblique appellate arbitral tribunal. Full stop. We are not in agreement with the plea made by the learned counsel for the appellant for the reason noted by the learned sessions judge in paragraph 37 of the impugned order, inasmuch as the clause 17 of the bylaws, which relates to jurisdiction of a court, confers the jurisdiction to the nearest court in terms of the address given by the what is the terminology used?
KYC, my lordship.
No, not KYC.
By the constituent.
Constituent in the KYC form. Full stop. Though the KYC form has not been filed, in terms of the conclusion drawn by the sessions judge, it appears that the KYC form incorporates the address of the appellant at Chennai.
I'm not sure, my lord, because it's in copies not here.
I said, even if that's kept aside, my lordship, my additional submission today is that the awards are drawn in accordance with section 20 and 31.
Even otherwise, even otherwise, the submission of the learned counsel for the respondent is that in terms of the bylaws, submission is that since the dispute has been referred by the NSC Chennai and the arbitral proceedings were held in Chennai throughout, Chennai has Chennai is the exclusive seat of arbitration and not venue, and as such it is the seat which would determine the jurisdiction of a court for the purpose of section 34.
My additional
of the Act of 96.
Just an additional submission which may be recorded, my lordship. Both the arbitral tribunals specify in the last line dated so and so and drawn up in Chennai. In the absence of an agreement between the parties, in accordance with section 31(4), this is the exclusive juridical seat.
Even otherwise it is, I don't think, see, once it has been referred, this would.
I'm saying that because of, even if the KYC form is kept aside, my lordship, it's an additional submission as operating by the statute.
What is your subject sheet? Just show us that, ma'am, arbitration.
Yeah. My lordship, if I may also show.
Oh, I think the exclusive seat jurisdiction is the conclusive. That
My
was
lordship,
very conclusive. Exclusive seat.
the juridical seat conferring exclusive jurisdiction.
Show us.
I'll just read out the clause, my lordship. My lordship has 31 subsection 4.
He also relies upon section 31(4) of the Act of 1996, which states that arbitral award shall state its date and the place of arbitration as determined in accordance with section 20, and the award shall be deemed to have been made at that place.
And my lordship will now have section 20 subsection 2, which is failing an agreement between the parties.
And he further submits that in terms of section 22 of the Act, since there was no agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal, having regard to the circumstances of the case, including the convenience of the parties. We are of the view that but tell us one thing. No, if KYC form also says Chennai, then that is conclusive. Okay.
There has been no dispute on that, and there is nothing on record to dispute this, including before this court. The question of whether the KYC form says Chennai or not is only following from my lordships. It's not been disputed at any point before we have appeared on the podium today.
Not sure about that, my lord, whether the KIC form.
Which is why I've submitted my lordship, even if the.
Show us that record.
Which is why I've submitted that even if the KYC form is discarded in its entirety, section 20 and 31 require it to be Chennai.
When is the KYC form filed?
I believe it was filed in 2010, my lordship, when she was registered as an authorized person with the NSE.
See, that's the point. See, why we say is, that jurisdictional cause also contemplate the change of address.
It does, and it's admitted that no such communication has been received.
How do we get that?
Again, my lordship, it's not raised in 4 forums before this court. In not a single pleading is a change of the KYC mentioned. There is no challenge to the KYC. Which is why, my lordship, I submit for the first time the question has fallen from the bench on what the KYC details are.
See, otherwise that's what confers jurisdiction on the court.
My lordship,
under clause.
My submission is that without prejudice to what the KYC form says, the arbitral proceedings in its entirety, like my lordship recorded, are in Chennai.
Let's assume KYC details says Bangalore.
Yes, my lordship.
Proceedings held in Chennai.
Yes, my lord.
Or the Chennai NSE has referred it. Okay, where will the jurisdiction?
It will be in Chennai, my lordship.
How? Go by the clause of jurisdiction. It
If-
will be the nearest of that place where the KYC details.
Then it should be Bangalore. I bow down, my
That's
lordship.
how.
I bow down.
So this submission of yours based on, 20C, 22, or even for the matter 31-4 would not hold. Once it is found under KYC, it's Bangalore, everything shifts to Bangalore, irrespective of the position. See, that's the concern of the court. It's actually the concern of, we want to know that. That's how.
My understanding, my lordship, if my lordship wants, I'll go through the trial court records to find that KYC form. My understanding is that it's not placed in the statement of claim, which is why it's not on record.
Because we say it was not placed, because it says there is a column, KYC column, that has not been ticked. KYC is not ticked. We don't want unnecessarily, to send a person to Chennai, otherwise she can make a claim here.
My submission here, my lordship, is that this contention has not been raised.
Let us look ourselves. See, these are the points you should.
Sir, sorry, I'm not, I could not.
And on what basis, we don't know. How does he draw a conclusion, the learned judge? Where is her appointment letter?
My lordship, the complaint which was filed initially to the National Stock Exchange of India, which led to the reference to the arbitration, was also addressed by the appellant to the NSE in Chennai.
That will not, obviously.
I bow down, I bow down. I
That's
bow
the
down.
only competent place who can, we want to know KYC details. Do one thing, we'll just pass over.
Yes, ma'am.
We want to know in KYC,
Yes, ma'am.
what is the address you had given? One,
Yes, ma'am.
did you apply for change of address in the KYC form?
Yes,
We want to know.
yes, ma'am. I will get the.
That will actually have a bearing on the outcome.
Yeah, that's what I just know. There was, according to me, my lord, subsequently she has not changed this. But if it is there, it is only Bangalore according to me because she worked.
No, it's important to change it.
Yes,
It's important. You may be representing from Bangalore.
yes, ma'am.
Unless and until you change it in KYC form, they will not take cognizance.
Yes, I will get the instruction from my client in the, when just maybe pass.
We'll just pass over.
Yes, my lord.
Then we will continue our dictation. Then we will tell you what has to be done.
Yes.
You're getting the point?
I do, my lordship.
So Chennai, then it will be seat, a venue, not a seat.
My lordship, my submission will remain that it is the seat.
That we will.
In which case, I'll take my lordship through one judgment. I bow down.
We will hear you on that.
I bow down.
So we are not conclusively drawing anything. Let's be clear on this. Okay?
My lordship, I'll take the TCR and just look if it's on the court's record.
Do that. No, we have checked up. Just good. You must look into it. Both of you must look into it.
Yes.
We'll just check, my lordship.
Yes, call the next man.
Serial number 4.
Yes, you bought the affidavit.
Yes, yes, ma'am.
So what was the issue was only on 11 lakhs. Huh?
Only 11 lakhs that clerical error. To that extent, I have filed my.
It was the bank guarantee charges.
That's right. Let's see the award, ma'am.
The award, the bank guarantee charges finding is at para 49, ma'am. On page 18 of the award, para 49 is the finding on bank guarantee charges.
So what you had argued was in the challenge is one, in any case, the trial court below says it is 11 lakhs. It's an error.
Yes, ma'am.
Now, what is the other finding on it?
My lord, in the award, my lord, the claims that were allowed was one regarding mobilization of labor, 5 lakhs, mobilization of machinery, 5 lakhs, and
Only 5
bank
lakhs,
guarantee.
5 lakhs and 1 lakh is here.
Yes, 1,72,000.
There is some basis for the arbitrator to come to a conclusion 5 lakhs need to be. See, that kind of a liberty and leverage is there with the learned arbitrator. You can't say that you must have, unlike an appeal, there is an evidence, then only we'll take a call. And that law is well settled.
My lord, in my
No, after 8 months from the date of award of the contract, after enter into an agreement, after submitting the bank guarantee, and he has made elaborate arrangements, entered into site, my lords. When entered into site only, he came to know that there is a problem with the land. Though informed earlier that there is a litigation, what prevented them not to award the contract is a question, my lordships. If there is a litigation, what prevented them not to award the contract? Once contract is awarded, we presume that there is no dispute.
My lord, here, as I had stated on the last stage, just to refresh, the agreement was entered into on 29/12/2015, my lord. And we have cancelled the work order within 8 months, 12/8/2016.
So this
So
was
the-
that land acquisition.
Yes, where we had trouble, the contract got frustrated, my lord. Yes, so the contract was
You say that
frustrated.
he had entered it. Obviously, he will enter it. If you don't do it, you will forfeit his bank guarantees.
Yes, my lord, we have informed that there is a litigation within 2 months of entering into the contract, my lord.
Did you enter it?
Because at that time we thought we had the land.
You had the land?
We had the land, my lord. Then there were
If
disputes
you thought
pertaining
so,
to the
he
land.
thought so, that there was a land available, he entered.
Yes,
Now you can't say the land is not available.
contract got frustrated, my lord. It was frustrated for reasons beyond our control.
Question of contract frustrated does not arise, my lordship.
Contract frustrated, he did not take it further. You cancelled it. You
Yes, my lord.
cancelled it.
We were unable to execute the contract. We were unable to do
See,
anything.
even
in
if
the
it says whatever expenditure, whatever expenses I have incurred
Yes.
after entering the
My lord, and even after intimating him that there is, that there are disputes, he still takes the risks and increases the price validity, my lord. So we've intimated him. That is recorded by the arbitral tribunal.
After all that, you have awarded the contract.
He was free to walk away, but he still
no.
took the risk.
See, that's what. Once he gives a bank guarantee, he can't
The
walk
bank
away.
guarantee charges, I'm not on that, my lord.
No, he can't walk away.
No.
Your stipulation would say, if you not take the contract further, your bank guarantee is what? This is performance bank guarantee.
Yes.
Yes, on the bank
If you
guarantee.
don't do it, you will forfeit it. How
Hello?
much is the bank guarantee for?
Around 71 lakhs, my lordship.
On the bank guarantee charges, I'm not on
Okay.
that, my lord. I'm only on the mobilization of labor and machinery, which in my respectful submission would be contrary to section 28(2) of the Arbitration Act.
What,
And-
saying?
My lord, the learned arbitrator has clearly given a finding that there is no evidence to support his claim that he has mobilized labor and resources. Clear is the finding that there is want of clinching evidence. In spite of that, only for being fair and proper, the court has awarded a sum of 5 lakhs under each one of those two heads, which in my respectful submission is clearly hit by section 28(2) of the Arbitration Act, my lord. And I place
Let's see what is the basis for the arbitrator to say so.
at para 50 of the award. At para 50 on page 18, my lord, the last 3 lines. This is regarding mobilization of labor. Even the possibility of the claimant deploying the labor for its other projects against the amount advanced in respect of the work in question also cannot be ruled out. Taking all these aspects of the matter into consideration, this tribunal deems it just and proper to award 25%. So it's just.
Because come to 50, the remaining 8% do not bear the signature of the receiving party. Out of 11, 3 payments are made through checks. On being asked as to whether the cash payments are reflected in the income tax report and the books of the account, claimants is no question to answer. Even assuming the amounts were advanced toward the mobilization of labor, it is not known whether any portion thereof is refunded by them. The possibility of the claimant deploying the labor for its own projects, other amounts to advance cannot be ruled out. Taking all these aspects of the matter into consideration, this tribunal deems it just.
And even regarding machinery also.
See,
my
it's
lord.
like this. You be right, strictly going by this, there is no clear evidence.
Yes.
But that kind of a, discretion is there. And we are in a 34th jurisdiction. He has taken a view. See, two views may be possible. Let's assume for a moment, what does he say is there is no clear evidence. But on the basis of certain things which have come account, out of 11, 3 payments were made through checks. That also he says. He exercises his discretion in his favor and say that we will not give complete amount. We will give you 5 lakhs. Okay, just take this. The challenge in this appeal is to an order dated order dated 15th October 2020, passed by the such and such civil court, Bangalore, in COM AS numbers 96 of 2019, whereby the sessions judge has rejected the suit filed by the appellant herein under section 34 of the Arbitration and Conciliation Act 1996. At the outset, learned counsel for the appellant would draw our attention to paragraph 5 of the impugned order, wherein the learned sessions judge has noted that the arbitrator has awarded a sum of rupees 1172,000 payable by the appellant to the defendant number 1 with interest at the rate of 8% per annum with cost of rupees 3 lakhs. As an erroneous conclusion, according to her, the arbitrator has awarded in all an amount of rupees
1,72,500.
no, just cut it. Paragraph
5 is correct.
No, not 5, not
11,
5.
11.
Not 5. He has drawn our attention at the outset, just cut that. At the outset, the learned counsel for the appellant has drawn our attention to paragraph 11 of the impugned order to contend that the respondent had claimed an amount of 1172,000 towards bank guarantee charges. Which aspect has been reiterated by, which amount has been reiterated by the appellant, by the learned sessions judge in the same paragraph, in the same paragraph. And also in paragraph 12, as erroneous. According to her, the learned arbitrator has in all granted an amount of 1172 to the respondent under 3 heads, that is under claim number 1.
Claim 1 is rejected, madam. Claim 3 for labor.
No, what is claim 1?
Claim 1 was for loss of profit, madam.
Under claim 1 and 3 for loss of profit. Under claim 1, he has awarded claim 1 and 3, he has
No, no,
awarded
ma'am.
5 lakhs
Two,
each.
two, ma'am.
3 and 4 is awarded 5 lakhs each. Ma'am.
Which
Claim 3 and 4.
Acha.
Claim 2, 3 and 4, my lords.
He has awarded under claim 3 and 4.
2 also. ma'am.
Amount, huh?
2 also, ma'am.
2 is for the bank guarantee.
Bank guarantee commission charges.
An amount of 5 lakhs each for loss of profit,
For mobilization of labor and machinery, my lord.
for mobilization of labor and machinery. Both were under 2 different claims.
Yes, different claims. Mobilization of
different.
labor, 5 lakhs.
He has also awarded under claim 2 an amount of 171,122.55. Full stop. This submission of the counsel for the appellant is acknowledged by the learned counsel for the respondent by stating that the reference to an amount of 1171 11,72,000 towards bank charges in paragraph 11 and 12 of the impugned order is erroneous. He has filed an affidavit today before the court, wherein in paragraph 2, the respondent has stated as under. Who is this gentleman?
P.
Who has filed this
Nagabhushan. P.
affidavit?
Nagabhushan. He is the managing director of the.
Has filed an affidavit of Mr. P. N. Nagabhushan, said to be the managing director of the respondent company. Is it a company or a proprietorship?
Now it was converted into a company. Earlier it was a firm.
Full stop. Having noted the contents of the affidavit, comma, it must be stated that reference to an amount of 1172,000 in paragraph 11 and 12 by the session judge is erroneous. The figure should have read as 171
122.55.
221.55.
122.55.
1171 221.55. Full stop. Insofar as the merits of the case are concerned, the learned counsel for the appellant would draw our attention to paragraph 50 and 51 of the impugned award to contend that the learned arbitrator has allowed the claim number 3 and 4 in favor of the respondent on just say 50, 51, 52, 53. Without there being an evidence on record that the respondent number 1 respondent had actually suffered loss of profit and has also mobilized the material at the site. Full stop. To answer the submission made by the learned counsel for the appellant, it is necessary to delineate certain facts which resulted in the contract getting frustrated. Full stop. This we say so for the reason that the respondent, the appellant had called for a tender for constructing a warehouse on plot number 1 in RS number 24/2 and 24/10 at Kangrali, BK Industrial Area, Belgavi. Full stop. On the respondent becoming the successful tenderer, the appellant had awarded the work to the respondent with a letter of intent dated 21/12/2015. Full stop. The approximate value of the work was rupees 1,326,52161. Full stop. 2016. And mind it, ma'am. One was the LOI issued December.
2015, my lord.
And in May, June, he's still asking for the site to be given.
Yes, my lord. Because in Feb itself, we have intimated that
Still
there
was
was a
dispute.
litigation.
Just say this.
That is fourth.
It is the case of the, it was the case of the respondent that even after lapse of 8 months from the date of issuance of LOI, comma, the respondent had not, the respondent had sent, the appellant had sent a cancellation order dated 12/8/2016. Full stop. The cancellation was on account of the litigation pertaining to the land in question. The claimant, the respondent quantified the claim of under claim number 3. Under claim number 3, that is for loss of profit.
Claim number 1 is loss of profit.
Well,
1 is loss of profit, that was dismissed.
what was 3?
3 is mobilization and
Mobilization of labor, my lord.
labor and machine.
Okay, mobilization. Okay.
20 lakhs we have claimed.
Okay. Where is that mobilization of labor? Which is that claim 3?
That itself is at para 50, my lord.
Para 50.
Where the finding is at para
The
50.
claim was 20 lakhs. He has awarded 5
The
lakhs.
claim number 3 and 4 were primarily for mobilization of labor and machinery. The claim as stated, as noted from paragraphs 51, 50 to 53. The claim for loss of profit, for mobilization of labor, on the ground that the respondent had paid an advance of rupees 20 lakhs for the same, full stop. It appears that the respondent had relied upon 11 vouchers which were exhibited at exhibit P55. P55 in support of his case for claim for mobilization of labor. Full stop. The learned arbitrator had given a finding that out of 11 vouchers, 8 vouchers did not bear the signatures of the receiving parties. Full stop. He also came to the conclusion that as 3 payments were made through checks, comma, and taking into account and had taken into account all aspects of the matter, granted 20%, 25% of the claim of 20 lakhs as awarded 20 lakhs, which amounts can be quantified as 5 lakhs. Full stop. The submission, insofar as the submission of the learned counsel for the appellant, that there was no evidence that in fact the respondent had paid the advance of rupees 20 lakhs towards mobilization of labor to the third parties. And in the absence of any evidence, the finding of the learned arbitrator is a perverse finding. We are not in agreement with the said submission of the learned counsel for the appellant for 2 reasons primarily. One, the tribunal, the learned arbitrator do conclude that 3 payments were made through checks, and also the fact that the payment of the checks was the relevant consideration which weighed with the learned arbitrator to grant the amount of 5 lakhs under the heading of mobilization of labor. Full stop. Surely surely there is some basis for the learned arbitrator to award the said amount. In that sense, it is not a perverse finding. The finding is not a perverse finding in that sense. Full stop. In that sense, it can also be said that just say this. Though the submission of the learned counsel for the appellant looks appealing on a flush bus, but on a deeper consideration, there being some basis for the learned arbitrator to award the claim in favor of the respondent, and no doubt, there can be two views on the basis of the evidence which has come on record, and the learned arbitrator having preferred to take a view on the basis of payment of 3 checks, this court is of the view that in exercise of power under section 34, such a conclusion cannot be interfered with. Full stop. Insofar as the claim number 4 is concerned, we have already reproduced the conclusion drawn by the learned arbitrator in paragraphs 51 and 51 to 53. 51 to 53. Full stop. In this, under this claim also, the learned arbitrator has allowed an amount, has allowed an amount of 5 lakhs in favor of the respondent. The claim, as stated above, is for securing the machineries and centering materials and their fabrication. The respondent had relied upon a work order, exhibit P52, in support of its claim under the said head. Full stop. The learned arbitrator was of the view. Where is P52? Is it on record?
It is on record.
Show us.
Not here. It is before the arbitral tribunal claim statement.
Show us. You have the record, ma'am?
No.
It
is on record.
Where is that?
We don't have that.
Oh. We don't have. No, but what is your take on exhibit 352?
My lord, I'll have to look into the.
Where is your ground in your petition on P52?
My lord, my grounds are not in respect of each exhibit, my lord.
It has to be that way, na?
Yes, ma'am.
Let's see. You don't succeed on claim 3. You may
Yes,
succeed on 4
Yes,
for certain grounds.
yes.
But what is your ground on P52? Are you denying that P52 is not meant for him?
Yes, my lord, we have denied all those exhibits, my lord, even in the cross-examination that was.
No,
Yeah.
what we are putting to is the learned arbitrator relies on exhibit P52. He says it is indicative of 5 lakhs advanced by the claimant to SR Enterprise. The same is reflected in the bank statement as exhibit P53. The work order dated 2/2/2016 is indicative of advance payment of 5 lakhs by the claimant to this. There is also a handwritten note at the bottom of the said work order that 5 lakhs is paid by checks on 5/3/2016. But adequate light is not thrown on the said payments in the affidavit filed the payment by way of examination chief. The bank statement to evidence the payment of 5 lakhs or 10 lakhs, as the case may be, is also not produced. The respondent side elicited in the course of examination this. I put it to you that the terms shown in the details of column 50 do not pertain the foundational works. Up to rafter in the said column, the items do not pertain to foundational works. I put it to you, sag rods, bracing rods do not pertain to foundational works. He says yes. You know what is the argument? Surely the material does not pertain to foundational works. What it pertains to is centering.
Column box. It starts from the very foundation level, my lord.
But tell us one thing, for foundational work, you don't require centering.
Below the ground also we require, my lord.
Then?
We require.
But how does this will help
So
you?
these column boxes, it is of 4 plates.
That's right.
that can be used for the foundational works. If we dismantle it, we can use it for the foundational works. If we just erect it, we can use it as a column.
No, but how do we say that these were erected or these were separate or these were in boxes?
So that was not the question before the arbitral tribunal. It is nut and bolt
Oh,
system.
very well. Now read 52.
Yes, my
Read
lord, the work was not even started, my lord. Not a single brick was laid.
Not understanding.
So there's no
He's,
question of-
you are not understanding. He's only saying, I have mobilized, I have kept it on the site.
Yes.
No.
No, not even on the
No,
site.
my
my lord.
lordships, I have placed order to the fabricator for manufacturing.
That's his case.
That's my case.
He did not say for centering items of this thing, I have mobilized, they have come on
No,
site. or
that
not.
is what he said. I received the payment.
C 52. The course of cross-examination is indicative of a part of ordered machinery material not required for foundational work, with which the construction busy. It is also not known as to what steps were taken by the claimant for recovering the advance. There is no condition in the quotation that advance amounts would be forfeited. The possibility of said ordered material being used for the complement project's works cannot be ruled out. Thus, there is a want of clinching evidence. These gaps in the evidence for immensely guiding sentence of the court in decision. But loss of absence of evidence of the amount of taking all relevant factors, he said. See, he concedes the learned arbitrator is open in his mind.
Yes.
He said this evidence may not be conclusive that he has actually, paid the advance. But the fact remains certain aspects at paragraph 51 do indicate certain payments were made. That cannot be ruled out. It is something like that is what he's saying. It is something, a discretion which has been exercised by the learned arbitrator. That's what. We are not in an appeal jurisdiction.
My lord, in a commercial arbitration, my lord, it's my respectful submission. In a commercial arbitration, the arbitrator being a creature of the contract, he can only do what the contract provides for. Here in this case, my lord, the arbitrator is acting justly and fairly, having given a finding that there is no evidence merely because it is just in and section 28.2, my lord, if I may just read section 28.2 of the Arbitration Act, it clearly says that the arbitrator cannot give anything as a just and proper manner. Section 28.2 of the Arbitration Act, my lord. Rules applicable to substance of dispute. The arbitral tribunal shall decide ex equo et bono or as amicable compositor only if the parties have expressly authorized it to do so.
I know that's 28.2.
28.2, yes, my lord.
That's
So it
28.2.
could not have acted fairly and say it is safe to award. So there's
If these contracts state so, even if you have mobilized the material, you cannot claim the mobilization, make any claim under that head, even if ultimately contract gets cancelled.
My lordships, small submission. Whether who committed breach of contract, on whose account the contract was frustrated, is it my fault? Contract frustrated?
You are not saying so.
No, that was my reading before the arbitrator, my lordship.
No, we are going further then. Then you have to answer this. Let's assume contract got frustrated, but still you have to prove your loss.
That is what
to prove your loss. That's what she is arguing. Where is the loss proved? Getting there? There is a distinction. No, frustrated. But this is the consequence that I have suffered loss. Where is the loss? Okay. Next, just say this. 52. But the learned arbitrator has not discounted the arbitrator, though says there is a want of clinching evidence, the gaps in evidence, clinching evidence, but taking the all relevant factors into pragmatic consideration, has awarded rupees 5 lakhs under claim number 4. As against what was the claim made by you? How much? 4?
Claim number 4.
25 lakhs.
25.
As against a claim of 25 lakhs. Full stop. In this regard, we may, full stop. Insofar as claim number 1 is concerned, claim number 2 is concerned, the same is for the bank charges paid by the appellant for furnishing a bank guarantee for an amount of
Paid by the respondent.
66 lakhs
respondent.
32
Paid by the respondent for an amount of?
It's forthcoming in para 49, my lord, 66 32 608.
For
Bank
an
guarantee
amount of
was 66,
32,
608.
608. Where do we get that figure?
It's
That is in
para
49, paragraph 49 of the award.
608. So the amount awarded by the learned arbitrator is 17122.55. Now, what was the basis for you to claim this amount?
This we have submitted the bank statement of expenditure. ma'am.
Full stop. The same is on the basis of the bank statements produced by the appellant. You have any issue on that?
No.
Full stop. The learned counsel for the appellant does not seriously dispute.
My lord, there may be an order of the court, my lord, the government of Karnataka
Very
organization.
well, very well. Full stop. This, suffice to state that the bank statements have not been contested by the appellants. Full stop. If that be so, and in view of the position of law, we will reproduce the judgments as laid down by different courts, delineating the scope of Section 34 of the Arbitration and Conciliation Act in certain fact situations, which include the fact situation which has arisen for consideration, for our consideration in this case, comma, just say 1, 2, 3. Full stop. We are of the view that given the position of law, comma, the challenge to the arbitration award, to the order of the session judge, is without merit. We reiterate that wherever there is a reference made to an amount of rupees 1172000 in paragraphs 11 and 12,
11 and 12.
as bank charges must be read to mean 1777721.55. Okay.
Just 1,72,000.
1 lakh.
1 lakh, it was rounded off as 1,72,000 by the arbitrator.
1,71,221.55.
Which-
That's the figure.
But that was rounded off as 1,72,000 in the final award, my lord.
Achha, which has been rounded off
It's 1 lakh.
as 1,72,000 in the final, in the award, as can be seen from
Para 16.
para
Para 60, the final.
which can be seen from the paragraph 60, wherein the learned arbitrator has reflected the amount as 1172000, the breakup of which is 1. There is a 177.
1172.
No. How can it be rounded off as 1? See, the
Because-
figure is.
Yes, my lord, what has been awarded is 5 lakhs for mobilization of
Yeah,
labor. my lord.
171. Where the breakup is 172,000 plus 5 lakhs plus 5 lakhs.
Yes.
That's the breakup. With the above observation, comma, the appeal is dismissed. Thank you. Next.
Serial number 10.
Where are those connected matters? Yes, ma'am. What are these? These are the same issues, when this affidavit taken.
Regarding the continuation of delay under 37, my lord.
Oh, yes, we will hear it. Come. Who are the councils? Who are the all other councils? Yes. Yes.
Serial number 11.
11, we will see. See, may not be taken up. We are not sitting after lunch. It's a different bench. So we'll just start. You start your submissions.
Very good.
My lordship, serial number 3, if my lordship want us to wait, my
Uh-huh.
lordship had given us a question. We checked the TCR records. The KYC form is not on record. It was never submitted along with the statement of claim. All the
Then
communication.
we will do.
What they had earlier.
If If my lordship may only consider, this is,
However, what has happened with both the parties, they pick the applicant and respondent. The applicants have corresponded with the respective address Bangalore, Mumbai only. And we could have
See, we'll tell you one thing.
Yes.
We are putting it to you. That's very important because the jurisdictional clause actually depends on that.
my lordship, this would be so in the case where it's an agreement between the parties. With the intent of the part, my submission is this. This is not a case where they have instituted proceedings in Bangalore and I am challenging the jurisdiction of a Bangalore court. They have instituted proceedings in Chennai. I have submitted myself to the jurisdiction of Chennai and I am saying they should maintain the proceedings in Chennai. This background is important. It does not arise from an agreement between the parties, which is where the intent of the arbitration and the intent of the parties comes in. Today, the bylaws provide this. They have themselves instituted the proceedings in Chennai and no objection has been taken up.
Now, where will they go then? Where will they go? Can
Chennai is the
they,
appropriate forum, my lordship.
1 minute. Can they come to Bangalore? Can they initiate at Bangalore?
The arbitration, my lordship,
That's right.
it was not done in this case, my lordship. If the
Yeah. Give a straight answer. They could have done it in Bangalore. Yes or no?
I would need to see
Yes
the
or
KYC,
no?
I would need to see the KYC form for that, my lordship.
That's right. So everyone will actually need to see the KYC form. See, the jurisdictional cause is clear. Let's assume for a moment, hypothetical. The Chennai, the proceedings held. The jurisdiction says in terms of KYC, if the address is in Bangalore, then it will be Court of Bangalore which will have the competence. That's right. Then you can't take that argument. You can't.
I bow down.
Everything falls down to the KYC.
My lordship, my
That's a provision, jurisdiction provision.
my submission also is this, my lordship, apart from matters like subject matter jurisdiction and pecuniary jurisdiction, here for jurisdiction of the arbitrators, both the parties have consented and submitted themselves before Chennai. Today, the party instituting the arbitration has never raised an objection to the jurisdiction of that arbitral tribunal. Having not raised a jurisdiction all the way till the 37 proceedings, even before this court is, I'm saying, based on an argument on the proceedings for the last 12 years.
No, 1 minute, 17 is jurisdiction of the court to challenge an award. Mind it. Very well. They need to attend the proceedings in Chennai, but when it comes to 34 stage, it would be here. It would be, according to them, Bangalore. See, the jurisdiction clause is the jurisdiction of the court. The court will come into picture only at 34.
No, my lordship, my submission is this contention has been rejected.
You read 17. Have you read 17?
I have none.
What does it say? Jurisdiction of the court? Yes or no?
I bow down, my lordship.
Then
Today, there is two positions on the reading of court in 17 and section 2. Section 2 has to be read conjointly with section 20 and section 31 of the Arbitration Act when an arbitral award is drawn up in a specific place and all proceedings are held in that place. I have one judgment, my lordship. I'll show the proceedings. I'll show the holding of the court. Today, there is nothing for this jurisdiction to lie in Bangalore. The proceedings were not held here.
it's a simple. Parties have agreed for a jurisdiction of a particular court in terms of these bylaws.
They have not, my lordship.
Why not?
There is no agreement between the parties.
Now then what is governing them?
The bylaws govern them, my lordship.
That's right.
Today, I'm saying a party is taking advantage of, even if they've instituted wrongly in Chennai,
May not.
they're taking an advantage of their own wrongdoing
They
for
will
14
not.
years.
They will say so. I think we are sorry. We'll do one thing. This matters. Can we have it another day? We'll have it after 2-3 days. Not your matter. We will complete this matter.
Sorry.
We will have it after 2-3 days.
Certainly.
We'll just finish it off. We don't
Certainly,
have
because
time.
there's a good proper point of law that needs some settling from this court.
Yeah,
We'll do that.
because we want to look into this. There's an interesting point.
That's true. That's true.
Just say that, just re-notify these appeals, ma'am, all these appeals now where this question comes. Which are the numbers in this?
I am in commercial appeal 92 of 23, which is at serial number 18.
18.
Serial number 19.
My lord, serial number 10.
18 and
18 point. Commercial appeal 129 of 23.
Yeah, whatever is there, give your
Number
numbers.
10, 10.
Just give it, ma'am, just note it down, ma'am.
One more battery.
Which is your number?
129, my lord.
No, of this list, today's list. What is the serial number?
29 of 2000.
No, 10
Serial
number.
number.
Serial number 10.
10. Which is yours,
18 and 18.1.
18 and 18 point. And you are also there?
No, Together, same, together.
Together.
Item number 11, madam.
11 is his. And that's all? We have 4 matters in all? Just re-notify. Give it next week.
612. 612. 612.
No, you are on the part of this batch. The jurisdiction, the limitation issue.
Continuation.
Limitation.
Delay, na? Okay, same date.
My lords, one more connected matter.
That we will see it. In any case, whatever view will follow be there, will be followed. Simple. Just give it date here, 6/12.
6, grateful.
Thank you. Yes, now come. Mr. Nilagi, where is your, this thing? What are your instructions?
30th of June 23, my lord, order was passed. For refund of this interest. And my lord, subsequently, my lord, refund was granted, my lord, on 18th.
Where is the council?
Wait, please, my lords. My lords, that is correct, my lords.
What follows? What follows?
Infructuous appeal becomes.
So we'll say so, you say so, it has become infructuous in view of this order.
Yes, in view of this refund order, my lord.
Where is that? We have one. We have kept it in the file.
Yes.
It was along with.
In fact, my lord, writ appeal was filed much prior to the my lord this.
I know, but during the pendency, you
Yes,
must
during
have
the
done this.
pendency, my lord, the amount was credited to his account on 18/7/2023 in pursuance of this order. On the very same day, my lord, this honorable court granted stay.
No, my lords, 10th July 23, my lords, I received it in my account.
That's what I must say. 18/7/23
Is the stay. 18/7/23 is the stay. 10th July is when I received the refund. Prior.
Who has, the learner counsel for the respondent has placed before us an order dated
30th June 23, last.
30th June
2023.
23.
Yes.
Passed under rules 92(1).
Yes.
92(3). 92(4), 92(5), and 96(7). That's right?
Yes, ma'am.
That's correct, my lords. Right.
Whereby, according to him, the appellant has sanctioned an amount of 78,73,057 as the amount payable to the respondent in terms of the impugned order passed by the learned single judge, which is under challenge in these proceedings. Full stop. A copy thereof has also been given to the learned counsel for the appellant. Full stop. Paragraph 7 and 8 of the said order reads as under. Full stop. Mr. Nilagi, on instruction in the matter in Kadana, just say this. Please. That a copy thereof was given to the learned counsel for the appellant who sought a passover to take instructions on this order. Now, furnished to the court by the learned counsel for the respondent. The learned counsel for the appellant on instruction states that the said order is in compliance with the order of the impugned order of the learned single judge dated 24/11/2022. Full stop. He also acknowledges that the said amount has been credited in the bank account of the appellant.
Respondent.
Respondent, my lords.
Full stop. He states that in view of this order, the present appeal has become infructuous.
No. That will also let that be an order.
No. Say so.
I said so for the better.
He say nothing. See, what is the consequence, Mr. Nilargi? We don't understand.
Consequence, that's what I said. Let there be an order of the court, my lord. In view of this, my lord, law should make kindly say.
We will say this way. Mr. Nilagi does not dispute the fact that in view of the order, the present appeal has become infructuous. That's right? Okay, just say this. In view of the order passed by the passed by the appellant, nothing survives for the, you want to contest this order?
No, my lord. This order, I cannot, my lord, I have to file a separate appeal, my lord, against this order. If I have to contest, if I want to contest this order, that is granting.
Does this order say subject to outcome of the writ petition?
It doesn't
of the
say so.
appeal?
No,
It
my lord,
doesn't
it
say so.
doesn't.
It doesn't say so.
Doesn't, my lord.
So we are suffice to state this order passed does not say that the order has been passed subject to the outcome of the present appeal.
It doesn't
Full
say.
stop. You were not knowing this.
No, my lord, I was not knowing this.
So
my lord.
that's the level. Full stop. In view of the aforesaid position, the present appeal,
Yes.
the present appeal has become infructuous. Full stop. It is accordingly dismissed as having become infructuous. Next, just take it on record, ma'am. Just note it down and take it on record.
Grateful, my lord.
Yes.
My lordship, I see what falls from the bench with specific question on the clause. Perhaps this may be considered today if the KYC document is not on record for the arbitral tribunal. Neither has it been submitted in any forum, including before the High Court. If the basis of the jurisdiction of a Bangalore court ought to have been the KYC form,
Correct.
at the minimum, it ought to have been submitted at the Section 34 filing. In the absence of a claim, both in the pleadings in the 37 filing as well as in the 34 filing, today the arbitral seat is determined as Chennai because everything has happened in Chennai. They have submitted to the jurisdiction. This would be a different case, my lordship, if that form was on record, in fact, for the 34 filing. It is not. In the absence of that, where everything has taken place in Chennai, they have consented to the arbitration, instituted the case in Chennai.
Not understanding that consent would not make any difference.
I understand. My lordship is saying that would be the venue of the arbitration.
Then it would be treated as a venue. Mind it, the parties have agreed to the jurisdiction of a court nearer the address or in the KYC. That's the sum and substance.
Yes, my lordship.
That will only come in 34 stage. It says court. What proceedings were before the arbitral tribunal, then the jurisdiction is irrelevant. It can be construed more as a venue, not as a seat.
My response to this, my lordship, would be this. I admit that this is the correct position. But when court comes in only at the stage of Section 34, it does not negate how the proceedings were conducted at both the earlier stages. Now, the position of law also is this today, that though something may be a venue in law, the determination of whether it is a seat or not
will not come in this case. We are very clear.
My lordship, my submission is...
Judgments are when there is no determination. Maybe for convenience, maybe there is a seat, but there is a jurisdiction clause here. And that jurisdiction clause is with regard to the court under 34.
I bow down, my lordship. Then my submission may be one of twofold.
Yes.
One is then the court has to hear this 37 on merits. If the court says that jurisdiction does exist today in the 37.
See, we are still ready to look into it, the KYC form. Possibly, the 34 court was right.
Possibly, my lordship.
If it was not, then we will go in merits. If he was wrong, then see, it's like this. If it was wrong, then we must determine. See, otherwise this will hold good for future. That interpretation of 17. And merely because he appeared before the proceedings before the tribunal in Chennai will not negate the effect of 17. It will still hold good. That's the point. That's the reason we say nothing. Then we will do one thing. We will not go ahead with the order. We want to see the KYC. We don't want to unnecessarily, drag a litigant to the court, which otherwise doesn't have the jurisdiction. If this court here in Bangalore had the jurisdiction, it has looked into it, we will then look into the merits. Otherwise, why trouble a litigant?
I bow down.
She is right.
I bow down.
That's right. So we will not go ahead, we will simply adjourn it, simpliciter. We are not going ahead with that order. Okay? Though there is an observation in 37 and 38 paragraphs of the learned trial court giving an indication that the
KYC
says Chennai. But we don't want to, we want to be sure. You have the KYC.
Right now, I don't have, my lord. I contacted my client also. my lord.
Yes.
Then we will just simply adjourn it. We will not take it, simplicity adjournment with an understanding. This order will not now. It will be only for him to bring the KYC form, if at all it exists.
I do see the trouble which falls from the bench and I bow down, my lordship. The KYC form I cannot deny today that it assumes relevance.
See, all your submission seat and venue would not come in
Yes,
this
my lord.
case. Would be on a different fact scenario. Okay? Very well. Just simply don't go with the order, man. You have taken that order? Okay, don't go with the order. Yes, just simply now say this. That at the request of counsel for the appellant, just say this, an issue of jurisdiction of the sessions judge has been raised. Yeah, you just say this, the impugned order of the session judge also holds that the court in Bangalore does not have the jurisdiction in view of clause 17 of the bylaws to understand, to answer the said issue. It is necessary for the appellant to produce the copy, the KYC details. KYC details. The learner counsel for the appellant seeks and is allowed how much time you want?
3-4 days time, because I'm told.
Till a week's time to produce the KYC form, if any.
Yes.
If any, on the next date of hearing.
Yes.
Re-notify.
Is a date being fixed, my
We'll
lordship?
give you date.
5/12?
Yes,
Sir, 5/12.
See, all these, those judgments, venue, everything in effect in a different, not in this. Rather, the judgments would be, the parties have determined the jurisdiction of a court, it will hold.
The only question I'm left with, my lordship, after the hearing today is if in fact the KYC form is not produced, then where does that leave the parties?
That's a point. Then we will hear you on that. We will hear you on that.
I bow down.
That's all, ma'am.
Yes.
7. 4 minutes.
Which one, ma'am? Yeah, call it.
Serial number 12. Srimati Shilpa.
Lord, I had made my submissions in this matter. Arbitrator has enhanced the compensation by 12 times. Taking into consideration.
We'll have it some other day, ma'am, not possible today. Okay? Just re-notify the appeal on.
5/12.
Yeah.
5/12, sir. Number
My
14.
lordship, sixth.
On sixth?
Sixth.
You just see sixth, ma'am. Our position. Sixth, no, then give some other date. 11th December.
List 2, serial number 2, my lords.
We are not taking up list 2.
Right.
Serial number 14.
Yes, ma'am.
Hearing for appellants, my lords, kindly seek for adjournment.
So we'll have it some other day. Re-notify.
12/12. Serial number 15.
Ma'am.
We'll have it some other day.
Please, I'm sorry, my lord, I could not be here in the forenoon. Apologies.
17/12.
Great.
That's it, ma'am.
Yes.
Madam Court Officer. Hello, Madam Court Officer.
Madam, ಹೇಳಿ madam.
16 ಅಲ್ಲಿ ಮಧುಸೂದನ್ ರಾವ್ ಬಂದು ತಿಳ್ಕೊಂಡು ಹೋದ್ರಾ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು?
ಬಂದ್ ಕೇಳ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ.
Okay, thank you.
ಕೋರ್ಟ್ ಆಫೀಸರ್,
ಹೇಳಿ ಮೇಡಮ್.
ಇದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ತಗೋತಾರಾ ಮಧ್ಯಾಹ್ನ?
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ನಾಳೆ ರಿಪೀಟ್ ಮೇಡಮ್, ಮಧ್ಯಾಹ್ನ
ಬೇರೆ ಬೆಂಚ್, ಸೊ ಮತ್ತೆ ತಗೊಳಲ್ಲ ಅಲ್ವಾ ಮಧ್ಯಾಹ್ನ?
ಇಲ್ಲ ಮೇಡಮ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Court officer, is it audible?
You will have to finish it.
Will do.
Otherwise, we can't, take out time. We have to break 2 benches.
We're most grateful, Milos. Milos, what we've done is, Milos, we've also prepared a written submission. I had, Milos, earlier when the matter was being heard by the Court of the Honorable Chief Justice, I had submitted a short synopsis. This is a slightly more elaborate version of that. So your Lordship may ignore that. I'll just hand this over. And then, Milos, there's a compilation of judgments, Milos, so that the relevant paragraphs I have also extracted in my written submission.
All the judgments.
Yes, Milos, of all the judgments except Milos, Vijay Madanlal, Milos, because it's a bulky one. Some paragraphs I've extracted, some
relevant.
The relevant ones, they're there. And Vijay Madanlal, Milos, I've already handed over. That's a separate spiral which I had given, Milos, which I had already read extensively from. And there are some more judgments and 2 or 3 judgments which have come, Milos.
Show the last hearing conditions. Now, Mr. Yadav,
please, Milos.
Why don't we take those arguments of yours? Just read that.
That's correct.
So we'll be able to.
Your Lordship is right.
Absorb it also.
I'm grateful, Milos. I just hand over. Because may I also hand over the compilation of judgments so that most of it is extracted in the written note only, but these are the judgments. Milos, the issue, Milos, which we had raised by way of a writ petition before the learned single judge, was that, Milos, in respect of the alleged offense of money laundering, arising, Milos, out of an FIR for the offense of cheating registered at Hubli in Karnataka, each and every transaction, Milos, involved a bank transfer from the complainant, one Mr. Godawat, Sanjay Godawat, to a set of builders, some 8 builders. My role, and applicant number 2, Milos, who's my wife, our role was confined to that we introduced these builders to the complainant and we induced him to make investments in their projects. Initially, we got very good results, returns. 1/3 of the amount has come back to us with profit to the complainant. Thereafter, Milos, the money is not come. Though, Milos, this is just the factual background. This is not so much for the jurisdiction part. This, Milos, we've raised in a section 482 where there is a stay on trial because some charge sheets have been filed. The investigation is going on. So, Milos, our sole grievance was that ED zonal office of Bangalore, ED's Bangalore zonal office cannot exercise jurisdiction when no part of the offense of money laundering is committed within the state of Karnataka. The registration of FIR in respect of the scheduled offense or the predicate offense in Karnataka is of little relevance. Money laundering, Milos, is a defined offense under the PMLA Act. It refers to named activities which are referred to as process or activity in Vijay Madanlal judgment. Those activities, Milos, are either you have procured proceeds of crime,
you have taken possession of proceeds of crime, you have concealed proceeds of crime, or you have used those proceeds of crime, or you have projected those proceeds of crime as untainted property, that amounts to money laundering. So our submission before the learned single judge was that any of these activities, whether these proceeds of crime have been procured by me or any of the accused builders, has been concealed here, has been used here to acquire some other asset within the state of Karnataka, only then ED's Bangalore zonal office will have jurisdiction. This issue, my lords, has not been disputed on facts even by the ED that no transaction, and there are more than 100 transactions, and all through RTGS, from the complainant's bank account in Maharashtra, 2 bank accounts, one is in Sangli, one is in Kolhapur, Jaishankar, subdivision of Kolhapur, to the builder's bank accounts, which are also Milords in Maharashtra, and most of them are in Mumbai. Not a single bank account where money has flown from the complainant to the builder as invested amount has come to any branch in Karnataka. Lordship may note, from the complainant to the accused builders. The accused builders and the complainant have utilized that money to jointly purchase properties for real estate development.
The accused builders
and the complainant. So here the person who has been cheated is also purchasing property with the accused, and no dispute on the title of those properties. It's not as if some fraudulent this thing, though I had nothing to do with it, but this is just the background. Now, where are all those properties located? Assuming this is proceeds of crime and that has been utilized to purchase properties, where are they located? Panvel, Raigad, Mumbai, Thane. Not a square inch of land has been purchased in Karnataka. Because all these things were undisputed before the learned single judge. None of these issues have been gone in. The learned single judge, Milords, accepts their contention, and their contention, Milords, according to us, is contrary to what, Milords, has been laid down by the Honorable Supreme Court in Vijay Madanlal, para 290. ED's contention, Milords, recorded in the impugned order is that without an FIR, we cannot do anything. The ECIR, or the Enforcement Case Information Report, cannot be registered unless there is an FIR. This, Milords, is contrary to para 290.
FIR regarding the
scheduled offense.
Scheduled
offense. Whereas, Milords, Vijay Madanlal Chaudhary, if your lordship may just kindly have page 2, Milords, I have extracted that very relevant paragraph, the very paragraph from Vijay Madanlal.
So you say the registration of predicated offense will not give any jurisdiction?
It will not. Though, Milords, I must confess, ordinarily the place of scheduled offense and the proceeds of crime will be common. Will be common, Milords. In a rare case, here it is rare, Milords, because even actually for the predicate offense, the FIR should never have been registered, but that's an issue I've raised in 482. And I had a stay. Then charge sheets came, then Milords, we filed withdrawn the earlier one, taken liberty, and filed a fresh this thing where there is again a stay. Here, Milords, this complainant who by his own admission or by his own statements in the FIR is a renowned industrialist. He has business operations in Karnataka. He is the only person who has a presence in Karnataka. All the accused, including me and my wife, are residents of Maharashtra. We have nothing to do with the state of Karnataka. We don't have any business here. We don't have any place of residence here. So the whole idea was to implicate them in criminal cases in a state outside Maharashtra to reach some kind of a financial settlement. And because these FIRs were lodged in 2018 and it's been going on. 7 out of these 8 FIRs, 9 FIRs have been quashed because they were, Milords, on identical facts. So, Milords, this honorable court in July of 22 in a writ petition passed a judgment quashing those 7, Milords, citing all those TT Antony and that line of judgments. Be that as it may, Milords. Now, Milords, in December of 22, that is more than 4 years after the registration, my investigation is still continuing there. Charges have not been framed, nothing has been, the investigation is still going on. Every now and then they file a supplementary charge sheet. In December of 22, Milos, ED steps in, registers an ECIR in that one FIR which was surviving. In that FIR, Milos, we file a writ petition questioning the jurisdiction on these grounds which I just narrated. Their contention, Milos, I'm coming back to that point, that we cannot initiate any investigation or even register an ECIR without an FIR in the scheduled offense is contrary to para 290. Lordship may just have para 2 of page 2 of my written submission now. Because bottom of the page, para 290 of Vijay Madan Lal Chaudhary. Milos, may I just mention one thing here? What has happened, Milos, is that this paragraph numbering is of the SCC online, which I have also handed over. After that, Milos, now the SCC, this thing print has come. So there, Milos, the numbering has changed.
You have given SCC online to us?
No, Milos. These are other judgments. Milos, that is a separate spiral. Which
this one.
That's the one. That's SCC online only. Just in case, Milos, if your Lordship, Milos.
That coincides with this.
This is identical, Milos. So, Milos, may I read para 290? As a matter of fact, prior to the amendment of 2015, the first proviso acted as an impediment for taking such urgent measures even by the authorized officer, who is no less than the rank of deputy director. We must hasten to add that the nuanced distinction must be kept in mind that to initiate prosecution for the offense under section 3 PMLA, registration of scheduled offense is a prerequisite. Lordship may mark the word prosecution. But for initiating the action of provisional attachment under section 5, there need not be a pre-registered criminal case in connection with the scheduled offense. This is again repeated in para 311, Milos. I'm just reading the highlight, the part in bold, Milos. The emphasis is mine, Milos. We have already noted in the earlier part of the judgment that before resorting to action of provisional attachment, registration of scheduled offense or complaint filed in that regard is not a precondition. And what does the learned single judge hold, Milos? Accepting their contention that an FIR is the foundation on which ECIR can be registered and ED can assume jurisdiction. So directly contrary to this. The judgment of the learned single judge is also, Milos, inconsistent with, Milos, what is now a well-settled position, that money laundering is an independent offense. Emphasized, Milos, in Vijay Madan Lal at para 269. Lordship may just have para 3 now. I'm sorry, page 3, Milos, para 5. I'm reading para 269, Milos, from Vijay Madan Lal. From the bare language of section 3 of the 2002 Act, it is amply clear that the offense of money laundering is an independent offense regarding the process or activity connected with the proceeds of crime, which had been derived or obtained as a result of criminal activity relating to or in relation to a scheduled offense. The process of activity can be in any form, be it one of concealment, possession, acquisition, use of proceeds of crime, as much as projecting it as untainted property or claiming it to be so. Thus, involvement in any one of such process or activity connected with the proceeds of crime would constitute the offense of money laundering. This offense otherwise has nothing to do with the criminal activity relating to the scheduled offense, except that the proceeds of crime derived or obtained as a result of that crime. Needless to mention that such process or activity can be indulged in only after the property is derived or obtained as a result of criminal activity, a scheduled offense. It would be an offense of money laundering to indulge in or to assist or being party to the process or activity connected with the proceeds of crime. And such process or activity in a given fact situation may be a continuing offense, irrespective of the date and time of commission of the scheduled offense. In other words, the criminal activity may have been committed before the same had been notified as scheduled offense for the purpose of 2002 Act. But if a person has indulged in or continues to indulge directly or indirectly in dealing with the proceeds of crime derived or obtained from such criminal activity, even after it has been notified as scheduled offense, may be liable to be prosecuted for the offense of money laundering under the 2002 Act for continuing to possess or conceal the proceeds of crime, fully or in part, or retaining possession thereof, or uses it in tranches, it should be, until fully exhausted. The offense of money laundering is not dependent on or linked to the date on which the scheduled offense, or if we may say so, the predicate offense has been committed. The relevant date is the date on which the person indulges in the process or activity connected with such proceeds of crime. Now, para 280, just Lordship may just note the part in bold. It is only when money is generated as a result of such acts that the 2002 Act steps in as soon as proceeds of crime are involved in any process or activity. Dealing with such proceeds of crime can be in any form, being process or activity. So, my lords, may I just take a hypothetical situation. Suppose, my lords, there is a kidnapping which happens, my lords, in Karnataka. But the ransom is paid, my lords, in Delhi. The proceeds of crime have a locus in Delhi. PMLA Act is meant to, my lords, confiscate the proceeds of crime. It is therefore most appropriate that the jurisdiction under the PMLA Act is exercised by the by the ED's jurisdictional office at the place where the proceeds of crime are delivered, ransom in this case. The FIR for kidnapping will be here. The investigation will be here. The accused may be wherever. The IO will be appointed here. That is the scheme. And Milos, the learned single judge, Milos, has disregarded all this and gone only by where the place of registration of FIR. Now, Milos, FIR registration, with utmost respect, is not a process or activity under Section 3 of the PMLA Act, which defines money laundering. Registration of FIR is not even mentioned. In fact, Vijay Madan Lal Chaudhary, which is prior in point of time to the judgment of the learned single judge, clarifies, emphasizes that it has nothing to do with the criminal activity of the schedule. It is an independent offense. It is a standalone offense. At several places. Milos, may I now urge your lordship to kindly have page 19 of this compilation, which I handed over today. There are, Milos, 2 or 3 paragraphs broadly on these lines, which I did not extract here, but which, Milos, this is a judgment also which has been, Milos, cited by the learned single judge. But with utmost respect, Milos, the ratio has not been followed. Milos, I am, Milos, referring to the judgment at page 19, it starts, Rana Ayub versus Directorate of Enforcement. My lord has that? 2023, volume 4, Supreme Court cases 357. There are 2 paragraphs, Milos, I'll read. Or 2 parts, Milos. First, Milos, para 32, because this will have a bearing on my next submission, applicability of CRPC to PMLA proceedings. This, Milos, has been provided for under Section 65 and, Milos, followed by the Honorable Supreme Court in para 32, Milos, at page 29, your lordship may see. Last paragraph at page 29. Page 29, para 32, Milos, bottom of the page. Therefore, it is clear that the provisions of the CRPC are applicable to all proceedings under the Act. Act is the PMLA Act, including proceedings before the special court, except to the extent they are specifically excluded, lordship may mark. Hence, Section 71 of the PMLA providing an overriding effect has to be construed in tune with Section 46 subsection 1 and Section 65. Because I have read this paragraph because that's my next submission. But on the issue of process or activity, there are 4 short paragraphs which I want to read, Milos. 3 rather. At page 33. 41, 42, and 43. Because I have put a small highlight there, just for.
Yes.
Because I've para 41, 42, because I have taken the liberty just to put a small mark, so that easier identification. Page 33. As we have pointed out earlier, the involvement of a person in any one or more of certain processes or activities connected with the proceeds of crime constitutes the offense of money laundering. These processes or activities include concealment, possession, acquisition, use, projecting as untainted property, or claiming as untainted property. In other words, a person may acquire proceeds of crime in one place. This is important, keeps the same in his possession in another place, conceal the same in a third place, use the same in a fourth place. The area in which each one of these places is located will be the area in which the offense of money laundering has been committed. To put it differently, the area in which the place of acquisition of the proceeds of crime is located, or the place of keeping it in possession is located, or the place in which it is concealed is located, or the place in which it is used is located, will be the area in which the offense has been committed. In addition, the definition of the words proceeds of crime focuses on deriving or obtaining a property as a result of criminal activity relating to a scheduled offense. Therefore, the area in which the property is derived or obtained or even held or concealed will be the area in which the offense of money laundering is committed. None of these fall within the state of Karnataka and not disputed by them. Now, Millers, the independent character of the offense of money laundering has been, Millers, emphasized in a judgment, Millers, passed by the Honorable Supreme Court in the case of Pavna Dibbar.
Where is the complaint in the predicated offense?
The complaint was in Hubli, Millers.
Is it here? Or
Is there?
Yes, yes.
I have an exception.
there?
Lordship may just have
Senior, on
page 102.
on the issue of jurisdiction, your claim, yes, this thing is there.
Please, Millers.
The proceeds of crime are not involved within the jurisdiction of this,
Please,
the authority concerned.
Lordship.
So hence it can't be that authority which can do it. Wherever they are,
That's correct, Millers.
that would be the competent court or competent authority,
Zonal office.
zonal.
Please, Millers.
Just tell us. There is the complaint.
Please, Millers. It's at page 102, Millers. Volume 1. It starts at 117.
Complaint is 117.
No, no, there were 8 FIRs in which me and my wife are named. No, they're all in Hubli, Milos. All in Hubli, though Milos, one is in a different police station. I don't know how Milos they've created jurisdiction in different police station, but be that as it may, initially Milos, I was named in 8 FIRs, me and my wife. 7 have been quashed. Then Milos, I have been charge sheeted in an earlier FIR also where I was not even named. So as of date, Milos, there are 2 FIRs or 2 charge sheets where me and my wife are named, and we have a stay in both of them. Separate 482 petitions, Milos. Please, Milos. The complaint, Milos, may I just start from the FIR itself, just to show, Milos, that even all the accused are residents of Mumbai. Starts at 102, Milos. Milos, the translation of this page is at 108, but just the date may be noted, Milos. This is 10th June 2018. It's been more than 6 years now. FIR in crime number 23 of 2018. Lordship, may kindly, Milos, turn over the page at 103 where the list of the accused persons are given. Milos, first 2 names are Milos, me and my wife, 1 and 2. Please see, Milos, our residence is Kolhapur, Maharashtra. Second, same address as my. Then again, Raigad, Maharashtra. 4th is Raigad, Maharashtra. Mumbai City, Maharashtra. Sangli, Maharashtra. Lordship may take it from me, all the named accused are residents of Maharashtra. Then, Milos, the complaint, if your Lordship may have, at page 117. This is Milos. Name of the complainant is right at the top, Mr. Sanjay Danchan Godawat, son of so-and-so. He has given his address as Hubli, Milos, so he is also a permanent resident of Maharashtra only, though he has business offices, he has business interests in Karnataka. His PAN number, passport, everything is of Maharashtra. Please, Milos. Because it starts at 117. From Mr. Sanjay Danchan Godawat, son of so-and-so, aged about 54 years, resident T3, 3rd floor, Kalburgi Green, near Sai Mandir, Vishweshwar Nagar, Hubli, Dharwad, Karnataka. To the Inspector of Police, Hubli, Ashok Nagar Police Station, Hubli. Complaint against Mr. Sheetal Kumar Sudhakar Manere, Mrs. Jyoti Sheetal Kumar Sudhakar Manere, Mr. Krishnamurthy Mudaliar, Mrs. Archana Krishnamurthy Mudaliar, Mr. Sheetal Magdoom, Mr. Ravindra. Then all the accused names are given. May I skip this, Milos? These are the same names, Milos, all residents of Maharashtra. Para 1, Milos. I'm a businessman by profession and carrying on various businesses and industry in the country. I'm the chairman of Sanjay Godavat Institute, director of Godavat Food International Private Limited, Godavat Industries India Limited, etc., and partner in Godavat Textiles, Godavat Consumer Products, LLP, Godavat Infra, and Godavat Industries, LLP, etc. Para 2, Milos. He makes a disclosure here about his business in Karnataka. Among my other business activities, I have also established factories at survey number so-and-so, village so-and-so, Hubli. I have my regional office in Hubli. In view of the above business activities, I visit Hubli very often. And during such visits, I reside at number 5, second floor, Kalburgi Green Apartment, first floor, Vishweshwar Nagar, Hubli. For the purpose of my business activities also, in fact, all the business associated persons interact with me at this place. I'm also in the business of manufacturing textiles and trading in the name and style of Godavat Textiles from the year 2005. In or around 2011, when I was in the process of buying new textile machines from the manufacturer, I came into contact with Mr. Sheetal Kumar Sudhakar Manere, applicant number 1, who was also in the process of purchasing textile machines from the same manufacturer. Mr. Sheetal Kumar Manere represented himself to be a big textile businessman and manufacturer. Myself and Mr. Sheetal Kumar bought several machines from the same manufacturer in 2011. Thus, we became acquainted with each other. The government of Maharashtra had made available certain subsidies to textile manufacturers under its textile policy. In the year 2012, there was substantial delay in the release of subsidy amount by the government. Mr. Sheetal Kumar represented that he knows concerned persons and that he would help me in getting the subsidy amount released. In this context, we visited Mumbai several times. All the paperwork and representations were prepared by Mr. Sheetal Kumar Manere and submitted to the concerned authorities, and it was represented by Mr. Sheetal Kumar Manere that due to his works and acts that the subsidy amount was finally released in the year 13. Taking advantage of this acquaintance, Mr. Sheetal Kumar Manere during the year 2012 approached me and requested me to give him textile manufacturing work on job work basis, holding out that he is in requirement of business. He also informed me that he would discharge his services honestly and to my satisfaction. Believing his words to be true, I agreed and gave the said work. Thus, our acquaintance turned into business relationship also. This conduct of Mr. Sheetal Kumar Manere, as well as the manner in which he behaved, made me to repose faith in him. Apart from the same, he also introduced his family members and became close to me and my family. During all these times, there have been several interactions between us. Mr. Sheetal Kumar Manere always behaved in a respectful manner and treated me as his elder brother and sought my advice in all his business and family matters, and in this manner, he got close to me. Mr. Sheetal Kumar Manere approached me with a proposal to do business jointly, and he suggested that he had various contacts with builders, developers, and that the real estate business would earn a lot of money. For this purpose, we incorporated a limited liability partnership in the name and style of Godavat Manere Developers in the year 2012. He later proposed me to purchase certain lands situated in so-and-so, Kabnur village, Ichilkaranji, Kolhapur, district measuring at 425,20,000 on so-and-so from Ram Sarup Purohit, and to jointly develop the same by us. Para 9 is important, Milos, because this shows that I'm actually investing in his businesses. Subsequently, Mr. Sheetal Kumar Manere once again approached me stating that he had certain funds available with him and that he would like to invest in the business ventures with me. More particularly, he was keen to invest in the consumer product business being run by me. Hence, an investment amount of rupees 15 lakh on so-and-so, 40 lakhs, 30 lakh on so-and-so, 30 lakhs, 20 lakhs, 17 lakhs. Because the amount is about 13 crores. Invested by the person who's today being accused of cheating the complainant. I'm investing in his businesses. So much so that he appoints me as a partner. After these amounts, Lordship may just note the amount is about 13 crores. I've counted it, was made by, Lordship may just have the last 5 lines. Was made by the said Mr. Sheetal Kumar, and he was inducted as a partner in Godavat Consumer Products LLP. Because the allegation of cheating is that the desired profits did not come. Initially, the desired profits came. He says so at 12. The invest, please, Milos, this amount is not what he's claiming as. This amount has gone into his firms. This is the amount which I have paid to him. This is not the subject matter of control. Milos, the investment, if your lordship see the FIR period, is around 2012. So I'm cheating him also and I'm investing in his businesses. Please see all these entries. 2014, September 14, August 15. And I will show each and every Milos payment is between 14 and 16 at page 127. He has mapped it. It's a 60-page FIR, Milos. But lordship, just allow me to just read one or two more paragraphs and then I'll show that map, that chart which is part of the complaint. Because I want Milos to stress upon his own statement in the FIR, in the complaint, that initially I got good returns. I'll not read the entire thing, Milos, just para 9 Milos of the complaint, where he's inducted as a partner in Godavat Consumer Products, Milos. Page 120, my lord has that. Lordship has page 120. Last 3 lines, Milos. Mr. Sheetal Kumar Manere also wanted his late son, Mr. Yash Manere, he Milos passed away later, to become a partner in the said firm. And hence Mr. Yash Manere had invested 20 lakhs on so-and-so, 20 lakhs, 35 lakhs, 45 lakhs. And he was also made a partner in the firm Godavat Consumer Products LLP, which carries on the business of running rice mills, manufacturing packaged drinking water, beverages, trading of savory, salt, edible oil, etc. in December 2013. In this manner, Mr. Sheetal Kumar endeared himself to me and he had multiple meetings with in order to earn my trust. Because the allegation is I do this whole exercise over a period of 3 years, invest my money in his account, in his companies. He is so happy with the investments, appoints me and my son as a partner. But this was all because I wanted to win his trust. Why? Because the game plan follows. At page 11, Milos. Or para 11, 12, 13, 14, 15, he's saying the same thing, Milos. The relationships are very good. We used to take holidays together. We were like family. He treated him like his elder brother. 16 is important, Milos, at page 123. During the year 2014, Lordship has already noted 2014, I have already made several investments. When I was in Hubli, Milos, page 123, Milos, Mr. Sheetal Kumar met me in the aforesaid address and informed that I should make investments in the real estate where I would reap maximum benefits and profits. He represented that he has several associates who are builders at Mumbai and Thane, Lordship may note, where there is a great demand for real estate development, and also a few of his friends have prime lands there. So my proposal at best was for Mumbai and Thane. He insisted that I should make investments. When I informed that I do not have much time to devote for the same, Mr. Sheetal Manere represented that he would assist me in ensuring that my investments would be safe and garner good profits. He also informed me he has teams who would help me assist in the business. I considered the proposal made by Mr. Manere. Thereafter, he introduced, then Lordship may skip all this, just please have para 20 of his complaint at 125. As per the advice and recommendations of Mr. Sheetal Kumar, Mrs. Jyoti, I agreed to make investments in few of the projects recommended by Mr. Sheetal Kumar. Initially, at the request and recommendation of Mr. Sheetal Kumar, I invested a sum of rupees 5 crores each in Messrs. A&A Shelters, Messrs. A&A Ritika Better Homes, and Messrs. Gaji Estate Private Limited, all represented by his directors, Mr. Abhishek Ramesh Vyas. 5 crores, 5 crores, 5 crores, he gives to 3 different people on my recommendations. Mr. Sheetal Kumar Manere had represented that these amounts would be made use of by these entities for real estate development, and hence the value of the said developed property would go up. I could benefit from the same either by selling it to third parties or by the developer buying the development construction from me. As per their representation, all the above 3 entities made payments of a sum of rupees 5 crore 90 lakhs each in July, August 2015 to me. This returns enhanced my belief on Mr. Manere and others above said persons, making me to believe that the transactions carried out by them are genuine. Thereafter, Mr. Sheetal Kumar Manere introduced Mr. Abhishek Suresh Asrani, stating that he's proprietor of Mrs. Chanchilda. These are all builders, Milos, who's into real estate business. He also introduced Mr. Mahesh Oza, proprietors of Karan Group, and developers Vivek Ramchand Dhamanse, director of Varad Infra. These are all accused builders. Vivek Ram held out that they are putting up constructions on prime localities, and in the event of me investing in their projects, the value of the same would go up after the real estate development. Please note, Milos. He's calling these proceeds of crime. The complainant, because he says only 1/3 of the amount has come back to me with profits. No, the profit has been given to him on the initial this thing. The first 15 crore. That's correct, Milos. That's correct. So it is Milos non-realization of expected profit is the foundation for accusation of cheating. Please, Milos. Milos, may I just read 3 more lines, page 126, Milos, where he again, Milos, admits that even this second round of investments yielded him good returns. Last 4 lines at page 126, Milos, where the accused builders are named, Milos. I've just read their names. Last 4 lines. Accordingly, I made certain investments with them, and in turn, they returned my investments with profits. They also made payments of various sums of money in the end of year 2014 and beginning of 15 as return on investments or capital to me. During all this time, Mr. Sheetal Manere categorically represented that the real estate business in Mumbai and Thane was booming, and that is the reason for the high rate of returns. He further represented that these areas would continue to boom and real estate business would flourish. Mr. Sheetal Manere and his associates having made available return on investments to me from time to time, and they having complied with their obligations, as also adhered to their representations, I was very much impressed with them and by their actions, due to which my trust in them grew. Para 22, Milos. Subsequent thereto, from the middle of 2015, Mr. Sheetal Manere approached me and stated that small investments would yield small returns, whereas big investments would earn big returns. And then, Milos, the complainant has given, Milos, over the next 6 pages, each and every transaction and the recipient builder made directly from his bank account to the recipient builder's bank account, not routed through me. All that he has said, I had introduced, I had recommended projects, not a single piece of evidence, not one email, one letter, one nothing. Except these bold assertions, but be that as it may, Milos, strictly speaking, that will be a ground for 482. But here, Milos, what we've done is, because the charge sheets have been filed, the investigation has been going on from 2018. So what we did, Milos, Lordship may just have volume 3 of the writ appeal. We have mapped from the bank statements forming part of the charge sheet each and every bank entry originating from the complainant's bank account to the builder's bank account. And all those bank accounts are in Maharashtra. Lordship may just have page 813 for a moment. This is in volume 3, Milos. I'm sorry, my lords. The statement of the accused recorded by the IO in the scheduled offense. No, my lords, I'm not sure if it's in the charge sheet also, because the charge sheet, my lords, one, my lords, I must. No, still going on. Still going on. They have filed a charge sheet, cognizance has been taken, but they're filing supplementary charge sheets every now and then. And now, so far, my lords, charges have not been framed, cognizance has been taken. And there is a stay, my lords, in my favor and my wife's favor. In the four. But the statement, my lords, it may be, my lords, it's all in, my lords, Kannada. So I have some statements we did get translated. But the charge sheet, my lords, I'm not quite sure, my lords, if 161. Please, my lords. The recovery, my lords, I'm sorry, I didn't follow. Please, my lords. No, there is no recovery has happened, my lords. No recovery. This was voluntary repayment by the builders when going was good. He himself has said, I've got good returns in 2 paragraphs. Please, my lords. My lords, the lordship is right, but that is a ground which I have taken in the 482. Please see what he says. Sheetal Kumar Manere. I read that paragraph. I did not emphasize, my lords. Just allow me to. Real estate business in Mumbai and Thane was booming, and that is the reason for high rate of return. He further represented these areas would continue to boom. Is that a representation for cheating? Cheating representation has to be an existing state of facts. I can say it will rain tomorrow, it may not. There is an inherent inconsistency. This is the ground I've taken in 482. That cheating is not made out. The representation has to be, my lords, with respect to all the builders are accusing. My role is intermediary because some money has come to me from the builders. I also used to invest with builders, my lords. 5 crores you're getting in one year, you're getting back. So I've also invested with them. These are all, my lords. 5 crores getting 90 lakhs in 1 year is 18%, my lords. Where he says the initial 5 crores. If your lordship sees the dates exactly in 1 year, he admits I've got 5 crore 90 lakhs. I've taken all these grounds in the 482. Why is the investigation not concluding, my lords? And my representation is that prospects are very good. Mumbai Thane will continue to boom. On that basis, and an amount of 500 crores, and not by some Pardanashi woman or someone who is illiterate or someone who doesn't know he himself is in real estate business. He himself is running institutions. He invests, himself is in, he's a much bigger businessman than I am. It's a friendship gone sour, my lords, that's all. In a nutshell.
Yes.
So, my lords, these we have mapped. Lordship may just have page 813, my lords. I just wanted to show this because this is the basis. This is the factual basis. This is the factual basis, my lords, of my entire case. Please, I'm sorry. Please, Milos, just 813 Milos, volume 3 of the writ appeal, where Milos, I have mapped from the bank statements forming part of the charge sheets. This is Milos before ED comes in. This is the charge sheet filed by in the schedule. This is Milos to show that all those amounts which have been invested by the complainant, by Mr. Godawat, in Milos, the firms of different builders, they involved bank accounts all in Maharashtra, and the properties that were also jointly purchased were also in Maharashtra, only for this limited purpose. My whole case, Milos, it's there in volume 1, Milos, 2016, Milos. I'll give the exact date. Milos, I was for one builder, Milos, I have the money which I got. Milos, some of my money is still with the builders. I would from the builders, Milos. Milos, in that case, they had filed a memo, Milos, before this honorable court in the bail cancellation proceedings. That will give the details, Milos, of the last payment that was made to me. Just allow me a minute. I found the document. I'll give the exact date. The last payment which has, Milos, come to Sheetal Kumar Manere. Details of payment made by builders to accused as per bank statements. The amounts are given. The date is not given. Yes, Milos. The amount from current group builders and developers, accused is proprietor is Mahesh Oza. The last, Milos, payment to me has come on 30th of May 2016. As per this, what they have mapped, payments may have come to me even thereafter, because I'm given to understand, Milos, that they still owe me some money. Then, Milos, in case of Siddhi Vinayak construction, it is 12th April 15. In case of NK Enterprises, it is 29th November 2016. In Varad, it is 25th April 2016, the last payment. Then there is one in 15, 16. Because as per at least the statement which they filed when they sought cancellation of my bail. But my bank accounts are also in Maharashtra. It's not as if that proceeds of crime. Nothing here. And not disputed, Milos. In all fairness, Milos, the ED did not dispute this before the learned single judge also. And Milos, for Milos, convenience sake, Lord, please, Milos.
Lord, my learned friend was reading the complaint. I had marked certain portions which would clearly indicate that the proceeds of crime are arisen. And I wanted to know whether he would read that or not. The moment my learned friend reached para 22, he conveniently switched to volume 3. So can we go back to para 22? Which he read about 3-4 lines and then he stopped to take up another volume. Page 127. Before that, my lord, your lordships have seen in the complaint that Sanjay Godawat, he says, he has set up a factory in Hubli. He lives in Hubli. He says all business meetings he conducts in Hubli. Now, please have a look at para 22 at page 127, where he says, subsequent thereto, from the middle of 2015, Sheetal Manre approached me, and when he says approached me, obviously at Hubli, and stated that small investment would yield small return, whereas big investment would earn big returns, and further represented I can own major areas of buildings being constructed and earn big profits. Induced by these representations and believing his statements to be true, and as I had implicit trust in Sheetal Manere on account of his manner and methodology, as well as that of his wife Jyoti Manere, I started making payments of higher amounts of money in terms of their request and recommendation. I have made the following payments. Then he gives a long list of payments made. For example, the first one is the A&A shelters, about 5 crore, beginning in 2014-17 and 19th of July. And then there are various other entities to which he makes payments. All of them run into about some 4 or 5 pages. And if your lordship would now turn to the end of that table at page number 132, the grand total is 551.50 crore. Now, what does he say about that? He says, all the above amounts were requested for and received by the above referred parties for the purpose of investment in the real estate development, which was to earn simple, suitable returns to me. Thus, a total amount, I have made a payment of rupees 551 crore. What follows is very important. All the above transactions and business discussions in this regard was held at Hubli, at this above said address. So he has, all these discussions were not only took place, he has made the payment from Hubli. So, my lord, all this, the modus operandi, my lord, he discusses at a later stage. He, according to the complainant, the modus operandi, he says, what Sheetal Kumar Manre did was, he said, please invest in this, you'll get some return. He made him invest. He got the return. And then he said, bhai, you know, you are making small investment, make big investment, take big profit. So when he made big investments, then he later realized that there is no such builder. There is no such construction which is going on. And then they enter into agreements to return the money. Checks are issued, which are all proceeds of crime. So he in no uncertain terms, the complainant says that the intention to cheat was there right from the beginning. Now, that is what the law laid down by the Honorable Supreme. Cheating means the intention to cheat must exist right from the beginning. There are several judgments on this proposition of law. So the very complainant very clearly says that he deliberately won my trust by making me invest and giving me returns on small. Lord, in fact, he uses the term, he describes the modus operandi in about 7 or 8 pages. It's a very lengthy complaint. He describes the modus operandi and he says how they all met in Hubli. There were contracts which were executed in Hubli. Yes, but generation and acquisition. Yes, acquired the Rana Ayub judgment. It also covers acquisition of proceeds of crime. The proceeds of crime was acquired from Hubli. Acquired from Hubli. No, and the complainant has paid from his Hubli bank account. The payment of money, it begins with the payment of money. My lord, any property which is associated directly or indirectly within any activity of crime, that is proceeds of crime. That is a very broad sweeping decision. So this money which Sanjay Godawat released from Hubli is proceeds of crime. It may have gone to Maharashtra, but it was generated in Hubli. He says everything was, he says business transaction, he says my business is in Hubli. No, my lord, on the definition, my lord, I'll take to your lordship. But on facts, my lord, on facts, he says, yes. Yes. Yes, 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 yes. That's broadly that is sufficient. I will give the other the nuances of that later when my turn comes. But eventually, after this, my lord, after they failed to pay, then there are a couple of MOUs entered into between the parties. And that MOUs also entered into in Hubli. Checks are tendered in Hubli to return the proceeds of crime by all these offenders, by all the builders, by the builders. But the allegation is that
By this accused also.
I stand corrected by the appellant also. Appellant also has received and has returned money, and several checks have been dishonored in Hubli. And my lord, the allegation in the complaint is that some of these builders would take the money, they would draw out cash or transfer money to Sheetal Manre and his wife. My lord, we have read only about some 22 paragraphs, but the entire complaint runs into, I think, close to about 100 paragraphs. He describes the entire modus operandi.
This issue of but Supreme Court directed them to conduct the investigation.
No, but his allegation, the police have registered because the money was transferred from Hubli account. No, but ultimately, please have a look at how that money. Yes, page 144. Page 144, the complainant says. Page 144, my lord, from the top about 6 lines below, the recipient of the money, one Mr. Abhishek, he says, he has also further informed me from out of monies received by him, he has transferred monies to Sheetal Manere, Jyoti Manere, and about 4 lines down further. He has further stated that he has made payment of huge amounts of money to Sheetal Manere. And about 7 lines further down, he has furnished their bank account to me and has claimed that Chanchal Das did not have money with them. From these bank statements, the clandestine transfer of money is proved beyond all reasonable doubts. So the bank transaction statements furnished by that Abhishek Asrani, who was one of the direct recipients, that indicates that how Abhishek received money from Sanjay Godawat and then transferred it to the appellant Sheetal Manre and his wife. So these were all designed that way. These transactions were designed that way. That is the case of the complainant. No, it doesn't matter. So long as what was generated from Hubli is proceeds of crime, it doesn't matter whether he receives in Maharashtra or Tamil Nadu. True. It is independent. Yes. No, for me, Lord, although the offense under the PMLA and as per Vijay Madan Lal Chaudhary, the offenses under the PMLA is independent, but both can stem from the same set of facts and transaction. Obviously. So here, the payment of money by Sanjay Godawat from Karnataka, which got transferred to Maharashtra, if it is proceeds of crime, the moment there is cheating, the entire proceeds, that money becomes proceeds of crime. So as far as we are concerned, that 551 crore which Sanjay Godawat paid from his Hubli account to various builders, a part of which this writ petitioner has also received, in entirety it is proceeds of crime. So which means it has been generated from Hubli, It may have traveled to Maharashtra. There is an attempt to bring it back by issuing checks. Yes, anything, my lord, where it travels, wherever the proceeds of crime travels, we get jurisdiction there. It generated from here. Yes, the generation of proceeds of crime is an area where we have got jurisdiction. I'm grateful.
There's one factual correction, Milods, and my learned senior may, Milods, verify in the meantime. No amount has been transferred by Sanjay Godawat from his bank account in Hubli or any other city or district in Karnataka. Please record my statement. I don't know how, Milods, the learned ASG. But the meetings took place here and therefore it is generation. Please, Milods. Milods, Milods, the statement, Milods, which has been made, and not once, Milods, more than once, is that the complainant transferred money from his Hubli account. It's factually wrong. To the builders. He said they may travel
Whether
to
it is right or wrong, it's a matter of trial.
No,
From the complaint, that is what emerges. He says, I have conducted the business transactions. He says, I have conducted the business transactions from Hubli.
Can the prosecution, Milods, add to the complaint
in 226, Milord, we cannot go into those issues at
certainly
all.
we can.
It is for the courts to verify. It's a disputed question.
226 is plenary jurisdiction.
Yes.
Where is it? Let him say where he's saying that from my Hubli account I have transferred money to the builders. Let my learned friend point out.
Transactions at Hubli.
Please, meetings. Please, Milods. All please, Milods. Is there even an iota of evidence? Or can, Milods, a bold assertion be taken? Please, Milods.
Yes.
Very well, Milods. Milods, no. I'm sorry, Milods. Please.
All those parameters which have been laid out by the Supreme Court must take place.
Lordship is right. Lordship is right. Milods, this para was read. And Milods, an impression was given that as if I have deliberately not read this paragraph. What does this para say? All the transactions and business discussions in this regard. What is meant by transaction means? Here, Milods, there are transactions. These are bank transactions. My learned friend is interpreted this to mean that the money has gone from the Hubli bank account. I am saying that he did not have a bank account in Hubli from which the money was transferred to the builders at that point in time. From Hubli. That I'm grateful. That's not even the case of the prosecution in the charge sheet. This is a totally new plea, Milods. Let them make good this submission, Milods. But they should not try and, Milods, say that this is 226 and everything will be a matter of trial. And so, Milods, may I now, Milods, because it's now become very important, Lordship may just have page 813. I'll not take more than 1 minute on this, Milods, because this is all page 813 of volume 3. Because now, Milods, the bank accounts have assumed, Milods, some significance. Milos, another clarification, Milos, another bold statement. No money, no check was given by me. Which, Milos, the builders gave the check towards settlement much after, Milos, the offense has been committed and laundering has happened, which has bounced and after those MOs in 2017. None of the checks were given by me or my wife. I had nothing to do with them. My transactions were with the builder. I'm being roped in now because you've introduced them, so you ensure the recovery of my funds. I'm answerable to the builders. Page 813, Milos. 813, Milos, volume 3. Or she may just have this chart, Milos. I would be hard pressed to see a bank account of the complainant or of the accused builders in any branch in Hubli or in Karnataka. These are all those transactions, Milos, which are mentioned in the FIR, in those 5-6 pages, those charts, tables. And these bank statements, Milos, were part of the charge sheet handed over by CID to ED. So my learned friend, Milos, I'm assuming must be aware of them. Please see, Milos, right at the top. This is the first builder. May I read, Milos? Payments made to Messrs. Chanchal Das, Abhishek, Suresh Asrani, S is for Suresh, accused number 1, on various dates by Mr. Sanjay D. Godawat. He's the complainant. Serial number, Milos, date. Amounts as per FIR 2.25 crores. Complainant's bank account and page number in the charge sheet. Builder's bank account and page number in the charge sheet. Then, Milos, serial number 1, I'm sorry, please see the complainant's bank account. Account number so-and-so 166, HDFC Jaisingpur, Maharashtra. Then I've given the page number in the charge sheet, not disputed by them. And this has been personally verified. Please see the builder's bank account, Milos, of Chanchal Das, proprietor Suresh Asrani. Account number 765, Kotak Bank, Mumbai Chembur. All of them, Milos, your lordship may record my statement. And for Milos, for easy visibility, I have Milos highlighted, or Milos, the bank branch is in bold. And there are only two banks of the complainant. HDFC Sangli and HDFC Jaisingpur, both in Maharashtra. And builder's bank account of this builder is Mumbai Chembur, Kotak Bank. Kindly turn over the page, Milos. One small fact, Milos. This accused, Suresh Asrani, had 2 firms. One was Chanchal Das Investment Group and one was Chanchal Das and Sons. He took 2 payments in the name of this firm as well. And interestingly, the first payment of 1 crore which he takes at page 798 is in 2012. Whereas as per his own averment in the FIR, I approached him in 2014 and proposed this real estate business to him. So he was dealing with this builder, at least one such builder, even before I gave him this offer to start investing in real estate, as per his own stated case. Be that as it may, Milos. Kindly, Milos, have page 815. And this is, Milos, I have taken the relevant statement from the charge sheet itself. This is the charge sheet in my case, Milos. This has now become supplementary charge sheet because the FIR in which this charge sheet came to be filed was quashed. But since the charge sheet had already been filed, Milos, the learned single just said this will be treated as supplementary charge sheet. But this was in case number 24, if your lordship sees, crime number 24. Crime number 24 today, Milos, stands quashed. Only crime number 23, in which ED has now come in, continues. Milos, what he did was there are 8 builders. On identical facts, identical wording, he files 8 different FIRs and saying they are all part of the same conspiracy, all are hand in glove, orchestrated plan. So the learned single judge said that all this can be investigated and won this thing. The TT Antony and Milos, Babu Bhai and Milos, all those judgments. But since Milos, some charge sheets had already come, they were treated as supplementary charge sheets. So Milos, this page number is from there only. But they are all part of 23 now. So this builder is Milos Nilesh Kumar Sable. And his firm's name is NK Enterprises. Kindly have the chart at page 800. This is straight from the charge sheet, Milos. This is not something which I have also mapped. Kindly have the date in the first column. Payments made by, these are all Sanjay Godawat, right till the end. It's not a very good print. Then the amounts 3 crore, 1 crore, 1 crore. We are not concerned. The total amount is right at the end 112 crores. Our bank means the complainant's bank. This I am assuming was given by them to the IO. So that same statement has been added to the charge sheet. Our bank is again HDFC Bank Limited. Please see the branch Jaisingpur, Maharashtra, Sangli, Jaisingpur, Sangli. All Maharashtra. Now see the builder's bank account. Next column, account number. Sorry, next is his only 166 and 435. These are just two accounts. Party bank. Party bank is the builder bank. Please see NK Enterprises, the builder's bank. Where is it? Punjab National Branch, Punjab National Bank. Next column, Nerul West. This is in Mumbai somewhere. All of them in one bank account. And was it check number or RTGS or NEFT? RTGS. It's not even their case that I also gave them cash and someone took it from me in Hubli. I could have still understood. Let's keep aside the evidence part of it right now. This is a case, where all the transactions have happened through RTGS. How can you then say that money is generated in Hubli? This way, the definition can easily be circumvented. The money laundering ingredients from Hubli or from any place in Karnataka. Not even their case, except the statement which has been made just now. Not even recorded by the learned single judge. Kindly turn over the page. 817 is just, I'm sorry, all Maharashtra, all within Maharashtra. Raigad, properties were purchased, Raigad, Panvel, Thane, Mumbai. This is a provisional attachment. There also all my properties that have been attached are also in Maharashtra. 16 or 14 of them. We filed it. I read last time from that. It's part of the record. Because this was filed by us with the memo on 2nd August 23. Because it must be oh, this is not a memo. Milos, I'm sorry, there's an IA for additional documents. Sorry. Your lordship is right. This date is wrong. Right? 23rd September 23. My lords are right. I'm sorry. I stand corrected. Please see the immovable properties that have been attached at page 67. Only my properties have been attached, and by way of a token of one another co-accused, not one builder's property. Who is the actual recipient of funds? In fact, I can show from the record, he is doing business with this Suresh Asrani even as I speak. They formed an LLP after the FIR was registered. Purchased 3 properties by way of a tripartite this thing. Everything overlooked by CID and ED. Lordship may just have page 67. This is the immovable properties, Milords, which they are calling POC, proceeds of crime. Let's see where they are located, Milords. I'm accepting them for the sake of argument, Milords, today, that they are proceeds of crime. 139 Milords. Please, my lords, conclusion of the piece here. Very well. These same properties are here also. Lordship is right. Conclusion and proceeds of crime identified. Shri Sheetal Kumar Manere. It is understood during the investigation conducted and the analysis of bank account statements and the statements recorded under section 50 subsection 3 of PMLA that Shri Sheetal Kumar Manere has received a total of rupees 43 crores in his bank accounts from the builders, namely Chanchal Das Investment Group, Karan Group Builders, Varad Infra Projects, NK Enterprises, Om Builders, Devansh, Siddhivinayak Construction. Shri Sheetal Kumar Manere has admitted in his statements recorded under section 50 subsection 3 of PMLA that he has received funds from the builders and utilized the amounts for the purchase of properties in his name and in the name of his family members, investment in his businesses, investments in windmills and film production, thereby layering and frustrating the proceeds of crime and assisting in the process of money laundering. It is also evident from his bank account statement of account number so-and-so held with Axis Bank. This is all in Maharashtra, Milos, and account number so-and-so held with PMC Bank, that he had transferred funds for the purchase of immovable properties from his bank accounts using the funds received from various builders. Hence, for the reasons mentioned above, the immovable properties mentioned below are nothing but proceeds of crime and this dash. Let's see the proceeds of crime, Milos. Description of the properties in column 2, Milos. I'll just read this. Final plot number 16 by 20, old survey number so-and-so, new survey number Ichal Karanji, so it's Taluk, Kolhapur district. Number 2, survey number so-and-so, and part of survey number so-and-so owned by Sheetal Kumar at village so-and-so, Mangaon district, Raigad, Maharashtra. Third, RS number so-and-so, CTS, Ichal Karanji, Hatkali, Alu, Kolhapur district. Fourth, old survey number, village Ghotpade, Taluka, Haveli, Pune district, bearing final plot number so-and-so, Sangamwadi, town planning scheme, Pune. Kindly turn over the page, Milos. These are all called direct POC, Milos. So they are all located in Maharashtra. Serial number 5, Milos. Survey number 19, Hissa number 1, village Dhamani, Panvel, Raigad, Maharashtra. 6th, page 142, Milos. Office number HG01A, ground floor, Heritage Block, Diamond Heritage, premise number 16, Strand Road, Kolkata. 7th, survey number 346, Dhanakhedi village, Ghatia Taluk, Ujjain district, MP. This is where my windmills are, Milos. 8th, windmill located at so-and-so, Dhanakadi village, Ghatia Taluk, Ujjain district, Madhya Pradesh. Then, my lords, at 3, it is also established from the statement of Shri Sheetal Kumar under section so-and-so that he has sold off some of the properties acquired through proceeds of crime. Hence, the below mentioned properties attached as equivalent value in respect of proceeds of crime already. House number so-and-so, RS number 116, plot number 3, Kabnur village, Hatkangle Taluk, Kolhapur district, Maharashtra. Then my wife's also, Milos, the property details are at page 144. This is also Milos, Ichal Karanji, Taluk, Kolhapur district. All these properties have been attached. They attach also one co-accused property, Milos, para 9.3 at 144. Sheetal Magdoom. 2 of his properties they attach and they are in Maharashtra. All the other accused are enjoying their properties till date. All those 8 builders, 8 or 9, who have cheated him, have not been proceeded against. And it's been close to 2 years now since ED stepped in. December of 22, Milos, this ECIR was registered. We are reaching December of 24 now. Milos, bias writ large, Milos. So please view it from any this thing, Milos, whether the flow of funds or how those funds were utilized by me. Today, Milos, this can be this is an issue of trial, that whether properties were purchased by me from my own sources or proceeds of crime. I'm not urging your lordship to, Milos, get into that scrutiny. I am saying I'm accepting your case as it is. I am saying that these are proceeds of crime. I am saying that yes, money has come to me from the builders. I'm even, let's say, assuming for the time being that those builders have cheated the complainant. There are ingredients of the offense of money laundering. How can you bypass those? I'm sorry, Milord. Single is fine, please, Milord. Milord's Lordship may have volume 1, Milord. The impugned order, Milord, starts at page 38. Milord, my submission is recorded at page 41, para 5. Milord, should I read from the beginning, Milord? Very well, Milord. Then page 41. Please, Milord, my contention is recorded correctly, but not dealt with. 41, Milord. Para 5. Para 5, Milord. The learned counsel appearing for the petitioners would admit that the solitary contention in the case at hand is that the proceedings suffer from want of territorial jurisdiction. And if the ED zonal office Bangalore had no jurisdiction to even register the ECIR, issuance of summons or any further proceedings would become contrary to law. It is his submission that none of the transactions as necessary under Section 3 of the Prevention of Money Laundering Act has happened within the territorial limits of Karnataka. Every transaction had happened in Mumbai, and therefore it is only the Office of Enforcement Directorate in Mumbai that would get jurisdiction to inquire into the offense under the Act. He would submit that the very provisions of the statute makes it unequivocally clear that the ED zonal office, Bangalore, cannot proceed against the petitioners. He would seek to place reliance on the judgment of the Apex Court in Vijay Madan Lal Chaudhary versus Union of India to buttress his submission that the offense under the Act is a standalone and independent offense, and therefore it has to be initiated only where the ingredients of Section 3 have happened and not elsewhere, and would seek quashment of the entire proceedings. Then their submission, Milord. On the other hand, the learned counsel for ED would refute the submission to contend that the ECIR cannot be registered until an FIR is registered under the scheduled offense or predicate offense. Without that, there cannot be a proceeding under that, contrary to para 290, which I read in the beginning, so Vijay Madan Lal, that without an FIR, ED can proceed. In fact, it says that in certain cases, to ensure that POC, proceeds of crime, don't get lost, you are supposed to take action without waiting for a formal FIR. So, Milord, their statement is, Milord, per se contrary to the... Milord, it is relevant because this is what the single judge records when, Milord, in the subsequent paragraphs. Please, Milord. Lordship. Very well.
This as a statement of law or a statement of fact, these may not be correct.
That's my submission. Yes. Very well. That's my limited submission. Admittedly, the crime is registered and charge sheet is filed in the jurisdictional court at Hubli. Therefore, the zonal... I'm sorry.
Yes.
Admittedly, the crime is registered and charge sheet is filed in the jurisdictional court at Hubli. Therefore, the zonal office Bangalore alone is competent to inquire into the allegations under the Act, as the two are interlinked, and would seek dismissal of the petition. Milord, 43, your Lordship may ignore, Milord. Para 8 deals with those 7 FIRs, those that were quashed, Milord. They are not so important. Para 9, Milord. As observed herein above, the contention of the learned counsel for the petitioners is that the Bangalore zonal office, which had registered the crime and now wanting to issue summons, has no jurisdiction to initiate proceedings at Bangalore. The plea of want of jurisdiction is raised on the ground that none of the transactions have happened in Bangalore, and in terms of Section 3 of the Act, it is only the offense office within whose jurisdiction the transactions have happened would get the power to initiate proceedings and issue summons in furtherance of registration of such crime. Since emphasis is placed upon the provisions of the Act to contend that the ED had no jurisdiction, it is germane to notice the provisions of the Act themselves. Section 2(1)(p) of the Act defines what is money laundering. Money laundering in terms of Section 2(1)(p) is as obtaining under Section 3. Section 3 reads as follows. Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, shall be guilty of the offense of money laundering. Explanation. For the removal of doubts, it is hereby clarified that a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with the proceeds of crime, namely concealment, possession, or acquisition, or use, or projecting as untainted property, or claiming as untainted property in any manner whatsoever. The process or activity connected with the proceeds of crime is a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untainted property or claiming it as untainted property in any manner whatsoever. Place of scheduled offense or registration of FIR is conspicuously absent. I'll proceed. Chapter 2 begins with section 3, which deals with money laundering. Whosoever directly or indirectly attempts to indulge or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, would be guilty of the offense of money laundering. Therefore, the offense of money laundering would be against any person who is involved in any process or activity connected with the proceeds of crime. The soul of crime is proceeds of crime. So far, Milos, I have no difficulty. Now, Milos, the proceeds of crime cannot spring from thin air. The proceeds of crime is to be based on registration of a crime. Therefore, the offense of money laundering, though is independent and standalone offense, cannot be without the foundation of registration of a crime, and it is proceeds of crime. This is a finding. Please, Milos. Lordship. Please, Milos. Please, Milos. Please, Milos. They can. Para 290. And there is a section which says that they have to give information to the relevant authorities. For investigation, there is no bar. For prosecution, there is. Vijay Madan Lal, Milos. Let's see that, Milos. I have extracted that in my note as well. Please. Please, Milos. Milos, the reason is this. Suppose it should not filter. Let's get the proceeds of crime under control first. That's the intent of this act. Please, Milos. Prosecution, your lordship is right. I'm at investigation. This is the mistake which the learned single judge has made. That para deals with prosecution, trial. There, Milos, I have no difficulty. A charge sheet. This is, Milos, may I just... Correct. Correct. You can even attach, provisionally attach. Provisional attachment is also there, even though FIR is not there. However, Milos, may I just take one hypothetical illustration? There is a dacoity in a bank. The learned single judge, Milos, and my respectful submission, has equated investigation with prosecution. In fact, the learned single judge says that the fulcrum of the analysis is that para which your lordship just referred to, 467. I am saying that para deals with prosecution, not investigation. Milos, lordship may just have para 290 because in Vijay Madan Lal, the Honorable Supreme Court has said there is a nuanced distinction between prosecution and investigation. Please, Milos. Please, Milos. That's correct. Milos, may I just take one hypothetical example before I read 290? Milos, suppose there is a dacoity. And my lords, there is no one who is willing to come forward to file an FIR. It happens many times because the FIR does not get filed. ED, Milos, gets the wind that the stolen jewelry or whatever has been sold to such and such traders in some parts of Mumbai jewelry market. Now, Milos, till the FIR is going to be smuggled out through some port, ED's hands cannot be tied. Otherwise, there would have been a provision under the Act itself that till the time you don't have, because if a fetter of this kind was intended by Parliament, what prevented them from putting this in black and white in the Act? That ED will act only when an FIR is registered. It's not there. And IO will act under CRPC only after an FIR. Because the investigation officer, the police, no, Milos, in the predicate offense, under the CRPC, the general investigation. This is a special statute, Milos, because the intent was that because Milos, the layering and how Milos, the money can get diverted. Milos, these days cybercrime is happening. Milos, may I just may I read 290?
ED would be very happy if your lordships would permit them to investigate even without a FIR. I would be, if your lordship would accept that submission and make it law, ED would be very happy. In the sense, it would be a very draconian weapon in the hands of authorities. My respectful submission is that even today, for the ED officers to commence an investigation, they need a FIR. They cannot assume the commission of a predicate offense or a scheduled offense. My lord, so many investigations are stayed by this honorable court for want of a registration of a FIR. We cannot do that. Civil action of attachment can be done. Against that, there is a remedy. Civil action of attachment will last only as to 30 days. Only 30 days. I can attach only for 30 days. Thereafter, it has to be placed before the confirmed adjudicating authority.
180 days.
But I cannot investigate.
Your lordship is referring to this offense, otherwise has nothing to do with. But 290 is even more clear, Milos.
It is sine qua non. Registration of FIR is sine qua non for us to.
No. This is contrary.
When my turn comes, I will read. But
lordship may have para 290, Milos. This is the first extract.
290 is in the context of section 66(2). Lord, that entire 290 may be read in its entirety. My learned friend read only half of it. No, we take only civil action. We take only civil action. Yes. 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 No, but prosecution also needs investigation. If I have to proceed against an accused against section 3, for that also I need to investigate. So how do we then draw a distinction? I cannot initiate proceedings under section 3 for the offense of money laundering without there being commission of a scheduled offense. Now, how do I assume that there is a commission of a scheduled offense unless there is FIR? No, that based on information, because that has got a validity of only 30 days. It's a temporary, only 30 days. Oh, then that authority will then. True. There, my lord, it is property. Here, liberty of an individual is attached. Under section 3, there is a liberty of a human being which is concerned. But there it is a property. Attachment of a property for a limited period. The maximum period is 180 days. that the authority also has to conclude it. But here, my lord, we are dealing with the liberty of an individual. The individual can be arrested. Under Section 3, it's a very serious offense. So which is why, unless there is a FIR, I cannot proceed. Yes. Not any investigation which leads to prosecution for the offense of money laundering. Yes, not in. No, ECR is required for both. Even for me to initiate civil action, I need a ECIR. But yes, I cannot investigate an offense under Section 3 unless there is registration of an FIR, which is sine qua non for me to investigate for an offense under Section 3. But as of today, the law is that I cannot proceed unless there is a registration of a FIR in respect of a scheduled offense. I cannot proceed.
So let him
Otherwise,
place the law.
courts have consistently interfered with our
Let him place
any action.
Milods, para 290, Milods. Lordship, may mark it, Milods. I've already read it. It's extracted in my, it's there in my written submission also. This is Milods, but may I just make one submission, Milods? One is, Milods, the power to provisionally attach a property is not for 30 days, for 180 days. It is only after an attachment under the Act, Section 5, for 180 days, not 30. It expires automatically unless it is confirmed by the adjudicating authority. The only obligation upon ED is that after provisional attachment, within 30 days of that provisional attachment, you will file for final adjudicating. That's correct. But otherwise, Milods, the language is, he may by order in writing provisionally attach such property for a period not exceeding 180 days from the date of the order. 30 days that he has to inform the adjudicating authority. He should not remain sitting, so that if the adjudicating authority wants to dismiss the provisional attachment, let's say on the 31st day, the accused should not be deprived of that relief. But otherwise, the attachment will run for 180 days. Look, your lordship may just have Section 5 for a minute, because your lordship asked a very pertinent question, Milos, that on what basis can attachment be done? The FIR is missing. It says where the director or any other officer not below the rank of deputy director authorized by the director for the purposes of these sections has reason to believe, the reason for such belief to be recorded in writing on the basis of material in his possession, that any person is in possession of proceeds of crime, and such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime under this chapter, he may, by order in writing, provisionally attach for 180 days. Because this is source information. ED has its people, contacts, and says that this is what is happening at this remote port off the coast of Kandla. Now, will the ED first find out if an FIR is registered with that activity? What if the local police station where this area is happening is... That's correct. Please note. That's right. Your lordship is right. Right. So Milods, ECIR can be registered without FIR, which has, because without ECR, there can't be provisional attachment also. That's like an FIR, or that's like, Milods, there's a formal entry. It may take whatever form. So their submission and acceptance of that submission by the learned single judge, that there cannot be an ECIR without this thing, according to Milods, in my respectful submission, is is incorrect. I'm trying. I'm trying my best. Just. Most grateful for a patient hearing.
Today is 29. Tomorrow is 29. Today is
Yeah.
29.
Hmm. Yes,
please. 29th of January, November. No, I'm sorry, Milos. Oh, no.
November.
I thought your lordship was giving date for 29 December was Sunday.
No,
No.
29 December we are closed.
No, that's what I thought. And it's a Sunday.
So this is day after tomorrow.
It was 29th, I'll be in some difficulty. No, it's what 13th is a Friday. 13th is a Friday, 13 December.
Very well.
Most grateful.
So would your lordship indicate any other day, assuming that we do not know by when my learned friend would complete on 13th?
Very good. 3:15. Lordship may give 3:15 minutes. There's some judge. Where 3:40.
That is 3:14.
The interim order, there's some protection. Most grateful.
ಇದು ಎರಡು ಫಿಲ್ ಮಾಡಿದ್ದೇನೆ I would have come. So you'll have to buy an apartment here then. Yeah, I realized.
I'll check the list and list even was not listed.